Good evening. We will call the meeting to order. I am Shannon Rutherford, the town planner, and this is our Town Plan and Zoning Commission meeting. And our first order of business is our administrative agenda, and we have the election of officers. And tonight we have, it seems Peter Zarella is absent this evening. He had indicated he may be, which is fine because we still have 7 members, which is 7 is the minimum needed in order to address the election of officers. And there's a vacancy in our board. So technically we have 5 full members and 3 alternates. I will start with a roll call of all the members present, and then we will, I will ask for nominations for chair this evening. Phil Cordero. Roll call. Phil, did I do that? Cordero, okay. Bob Canto.
Here.
I noted Peter Zarella is absent. Liz Sanford.
Here.
Dave St. Germain.
Here.
Tyler Pogson.
Here.
Josh Davidson.
Here.
And Rob Ingbertson.
Here.
Okay. With that, we will go to the first order of business, which is the election of officers. I will take a nomination for chair, please.
I would like to nominate Liz Sanford for chair.
Okay. And is there a second?
Second.
Any other nominations for chair? Okay. And is there any discussion regarding the nomination for chair? For Liz Sanford as chair?
Sure. I'd just like to say Liz has been on the committee for several years and has been served as secretary and done a great job. And look forward.
Okay. Thank you very much. With that, we will call for a vote. We can do individual. We will try all, and if needed, we can go to individual roll call vote. So all in favor, please signify by saying aye.
Aye.
Any opposed? Any abstentions? And then I will call for nomination for secretary, please.
I'd like to nominate Dave St. Germain for secretary.
And there's a second.
Second.
Is there any other nomination for secretary? Any discussion regarding the nomination?
Just that I'd like to say thanks for stepping up, Dave, and it will be a pleasure to work with you if elected.
Okay. All right, we'll do the same. All in favor of Dave St. Germain as secretary for the term, please signify by saying aye.
Aye.
Any opposed? Any abstentions? Okay, hearing none, it passes. Thank you very much. Okay. The next item of business is review of bylaws. So those were sent to all of you. If there's any comments, we can discuss them now. If it's something that everyone wants to read and consider, this can be considered at subsequent meetings. If something comes up, then we can address it. It just needs to be discussed at a prior meeting before being voted on at a subsequent meeting.
I'll just chime in real quick. And I did have a question on Article 10, Section 2. So this section, just briefly, as I understand it, encourages applicants to appear before this, it says board, but I guess commission, I don't know, board commission, to informally discuss their topics and their proposals. And I mean, I've attended several meetings of this commission in the past, and the informal process sometimes seems to be a de facto hearing without some of the legal protections provided by state statutes, including public notice and public comment periods. And so I wonder if this is something that we could consider either striking the section potentially entirely. It's just a suggestion at this point, as I read it, or potentially adding some sorts of restrictions that we could discuss and debate and decide in terms of ensuring that public comment is available during these sessions, and that there's proper notice provided to neighboring properties, and that it doesn't become sort of a de facto public hearing without those protections. So
Okay, well,
Just-
we couldn't include the public or provide notice, otherwise it does become a public hearing. But you're welcome, perhaps as part of our next session, have that conversation with our town attorney. It is specifically permitted in the Connecticut General Statute. And it is limited to, the scope and scale of the conversation is limited in the bylaw. It is limited in the statute as well. But that's certainly it's the commission's choice ultimately, but perhaps
Yeah.
Attorney DiCrescenzo may have some thoughts on that and how appropriate an informal discussion is with the commission.
Yeah, and I guess even if we strike this section, my understanding is it wouldn't preclude us from having an informal review if, I guess, the commission so decided. This section, as I read it, it's a weird sort of suggestion to applicants, which I'm not sure that applicants even see this necessarily generally. They're not going to see the bylaws. So, yeah, so something to consider, I think.
Any other items for discussion at this time?
I have one, and it's not a big deal, but in the past, the orders of business, and I don't know if it's something we have to stop doing in the beginning, or if we go session by session, but we've never done the Pledge of Allegiance. And it says that that's the second thing to do. I don't
Good point.
I'm doing it. But I know, Liz, we've never done it. I don't know if it was just an oversight or,
No, I think it dropped off during COVID.
okay,
So-
maybe.
It dropped off during COVID, would be my guess. So
Okay.
It's completely up to the commission if they'd like to.
Pros, cons, and it adds what, 35, 40 seconds?
Seconds.
I don't
I think
typically
it's-
I know the town council does, the other land
Right.
use boards do not, but that doesn't mean that we can't.
I don't see the need to personally.
Okay. I am willing to go either way. And would you like to? I mean,
I wouldn't mind doing it. I would think it would be a nice way to start off. But let's see what everybody else thinks.
I've been in other meetings where we've always done it. In other organizations I belong to. And I mean, it's just something we've always done.
Okay. Any feelings one way or the other?
No.
Feelings one way or the other?
I say every day at school. So.
I do too. Usually.
Okay.
Josh, any?
No comments.
Okay. Well, let's put it back in.
Reinstate? Okay. Sure. Got it.
I did actually notice that too, Bob.
You know,
Like-
it caught my eye. I was like,
Shannon, I just had one procedural question for you. So in Article 10, Section 3, public hearing items must be submitted 20 days prior to the next regularly scheduled meeting. Are those materials then always made available, either 20 days or very soon thereafter for public hearing?
So we typically try to get them posted at the time that it's accepted on the agenda. So that was the purpose. So that was a regulation that changed during Bill Warner's tenure. So sometime between 2015 and 2018 or 2014, 2018, there was no accept an application. It had to be submitted 20 days in order to get the legal notices done. but there was no other notice of the of a particular application. So it was a legal notice. It appeared on the agenda, so it at times would only appear on the agenda once and be addressed that same evening. So the bylaw changed to require it appear to be accepted. So it appears at a minimum twice on the agenda to be accepted, and then for its hearing. The 20 days is so that the legal notice can be done and we can review the application. It is, to the best of our ability, uploaded to the website at the time that it's accepted on the agenda. At a minimum, it is done at the time the legal notice is released, because at that point it needs to be available to the public. Obviously, anyone can come to our office at any point in time.
Yeah.
And get those documents.
So generally 2 meetings a month, 2 weeks between, it's 14 days.
Right.
Ish.
So generally, we're accepting, if you accept an application at the first of the month, the hearing's set for the next first meeting of the month. If it's accepted at the second meeting of the month, then the hearing is set for the next second meeting of the month.
So long as, according to this rule, though, so long as the actual hearing items, I guess, are submitted.
Oh, correct. It's submitted with the application. So as part of the application, if it's on your agenda for acceptance, then the application is substantially complete.
Okay.
Now, that's not to say an architectural elevation hasn't been submitted or a photometrics plan hasn't been submitted at the time that the application is submitted and the item is scheduled for hearing. So it's substantially complete.
Okay.
At times, there are elements that are, an applicant, whatever, but they're a consultant, they're waiting on a final item from their consultant.
Okay. Thanks for the clarifications.
Sure. Anything else? Related? Not yet. Okay. All right. Well, we will reinstate Pledge of Allegiance. We can discuss further informal meeting. If there's no further items regarding this, we can adjourn the.
So Shannon, sorry, just as follow up. So where would we discuss, or how would we discuss the potential for informal meetings? I guess, would that be a planner's report item in the future? Would we put it on the agenda potentially? Like, how does that?
Well, my suggestion is let's chat with Attorney DiCrescenzo.
Okay.
And then if that's something that the commission in a whole wants to discuss, yes, it can be added to the agenda for discussion. And it can start under planner's report, or it can go as an official item if we want to go right to that.
No,
And it says amendments to the bylaw. These bylaws may be amended by a 2/3 vote of the entire membership of the commission after the proposed change has been distributed to all members and it is read and discussed at a previous regular meeting.
Great. Okay. Thank you.
You bet.
Appreciate clarifying.
Okay, so we will at 7:14 adjourn the administrative meeting. And we will call to order the regular meeting. I will note for the record that we have the same members in attendance. And if I may ask for a reordering of the business to start with the land use training, if we can have a motion second to reorder the business for this evening, start with the land use training. And then we as a commission can review the new business and meeting minutes subsequent to the land use training, since our town attorney is here and ready to start.
I'd like to make a motion that we do what Shannon just said.
That's awesome. I'll second that.
Thank you.
All in favor?
Aye.
Thank you very much. All right, Mr. DiCrescenzo, you are up.
Evening for everyone. And,
Bob DiCrescenzo from the firm of Updike, Kelly and Spellacy. And we have been serving as land use council for quite some time. And we do this every 2 years. So what this is a very broad overview of land use law in the state of Connecticut. It is not intended to be an in-depth analysis of any particular issue. It's more an overview of the different roles and responsibilities of each of the land use commissions. Next slide, please. So we're going to go over that, but before we do that, I just want to talk briefly about land use law in general. And as you may know, land use law is strictly a exercise of statutory power. There is no common law of land use. And there's a very good reason for that. The regulation of land in the United States really began in the 1920s with the United States Supreme Court case of Village of Euclid versus Ambler, which is the seminal case in land use regulation. But if you step back from it a minute, the court was faced with a very interesting issue. Of course, we have the due process clause, which says that the government can't take anything from you without due process of law. And you could make the argument that the regulation of your land is taking something from you without due process. So how does the court get around that? Well, the court found in Euclid that land use was really an exercise of the police power, not, and therefore did not fall under the restrictions of the due process clause. Now, why is that important? Well, due process, you can't take anything from someone without due process of law and compensation. So if the town of Farmington wants to regulate my land and tell me there's only these uses that I could use for my land, well, perhaps that requires compensation. But if it's justified under the police power, which is public health and safety, then there's no need for compensation. It's exactly how the court decided it. So given that background, states across the country and municipalities started to adopt zoning, what's called Euclidean zoning, which is the term used to describe the division of towns to zoning districts and restriction of uses within those districts. Now, we've come a long way from that initial characterization of land use law, but it's always, in my view, really important to remember that's where this all came from. And when I say it's strictly statutory, I think members who've been on the commission long enough are always admonished that the commission can't do anything that's outside of its statutory mandate. Can't go beyond what the state of Connecticut allows you to. The other main topic or theme tonight is land use law in Connecticut is changing rather rapidly. And we are proudly the land of steady habits and also proudly land of local control. And that finds its greatest expression, I think, in local zonings, local land use controls. And as everyone in this room knows, there is a very big issue with affordable housing in the state of Connecticut and frustration by state leaders over the lack of so-called affordable housing. And the state legislature has stepped in a very big way in the last few sessions and passed laws that take away, to some extent, local control and prescribe how certain uses will be treated within your zoning regulations. And we'll get into a little bit of that. So that's really the prelude to what we're going to talk about tonight. But the first is the role of the commissions. And there are principally 5 land use commissions, 4 of which have regulatory power, 1 of which has advisory power. I mean, regulatory power is regulations that are enforced that can dictate how you use your land. And that is the zoning commission, planning commission, zoning board of appeals, and the inland wetlands agency. And given that we're in Farmington, I'll also add to that list the historic district commission. Because if you live within the boundaries of the historic district, the historic district commission has very real powers and authority over how you use your land. The last commission is the Conservation Commission, which is advisory. Lots of towns group that commission in with inland wetlands, but you should understand that they have very different roles and responsibilities. And at any point, if you want to ask a question, please do. Because I don't want to just stand up here and talk to you. I'd really like this to be somewhat of a conversation as we go along.
Bob, can I ask a very quick question about
Sure.
something you just said? The Conservation Commission is advisory. To whom do they advise?
They advise to inland wetlands. They advise to, don't have the statute in front of me, but I believe they also advise to the zoning commission and to some extent to the planning commission. It's the other land use agencies really. So I'll have to look at this screen because I used to be able to see that screen, but I can't.
I can see here. Is that better? Is that better?
Yeah, that's better.
Okay.
I still can't see.
Can't see that one.
It's okay here. So the zoning commission, the role is to enact, amend zoning regulations, zoning changes, act on special permit applications and site plans. The workhorse of the zoning commission, of course, is the review and action on site plans, as you all know. And the site plan is just what it says. It's a plan to develop a site. Over the years, towns have gotten very sophisticated as to what is required for a site plan under the regulations. And in conjunction with that, there is the special permit applications, which is, as you know, towns have identified a great number of special permit uses within a zone. And all of your zones have regulations as of right. We use a residential zone as an example of that. You want to build a single family home within the residential zone. You go to the regulations, you find out your dimensional requirements, side yards, rear yards, lot coverage ratio. And if you meet all those requirements, then you get a building permit. If you want to build a business within a zone for which there is an authorized use as of right, you file a site plan to show where the driveway is and all the other aspects, and you get your approved site plan. And then there's a whole other classification of uses within virtually every zone called a special permit, which means that the commission gets to look a little bit more deeply into the use to determine whether or not the use is consistent with the overall goals and objectives. And towns, as you well know, have gone increasingly to classify any number of uses as special permit uses in order for the commission to exercise more control over how the use will fit on the land. Used to be that accessory dwelling units, for instance, were special permit uses, still are, but here in Farmington, you've sort of done your ADU regulation in two different ways, as you know. But special accessory dwelling unit is a good example of the special permit use because it really creates two dwelling units where there was one before, and aspects of the site. Do you have enough room for the parking? Does it fit within the overall character of the neighborhood? Although it's very tricky these days to have the regulation that says overall character of the neighborhood. But you get the point. Special permit gives you a little bit more authority to look at how this use on this lot will work. Statutory authority is General Statutes 8-2 and General Statutes 8-3. Now, zoning commissions act in two different capacities. One is a legislative capacity and the other is administrative capacity. And they have very different rules associated with them. When you're acting on a site plan, you're acting in an administrative capacity. And the issue there is, does the intended use, proposed use on the site plan meet the objective criteria for the site plan, for the zone? If yes, it must be approved. Where you are acting in a legislative capacity, such as a zone change application, you're doing just that. You're acting legislatively, and your discretion is much broader. And absent any procedural infirmities, courts are very largely unwilling to substitute the court's judgment for your judgment on legislative acts, such as a zone change. Administrative acts, courts will say, hey, look, you had no discretion, it met your regulations, you turned it down, you didn't have the authority to do that, and they will return you much more readily in wrongful denial of an administrative action.
Bob, I have a question on that.
Yes.
So, when you said site plan is, administrative, does it meet the objective criteria? So over the years, I've lived in town my entire life, but over the years, I've seen a lot of projects come in that the public aren't happy about. Stuff that I haven't been happy about. And where does public say actually come into play here? Because if some big development firm comes in and says, well, we want to tear down, all these acreages of woods, and the town has the opportunity to say, buy that for open space instead, why, and say the public wants that, why would we go forth and let it go through just because it meets all the requirements if the public doesn't want it?
Well, that's an illustration of why I started out the way I did in terms of the authority of the commission under the statutes. You only sit and pass judgment on the use of land by virtue of your statutory authority to do so. And again, we have to start with the premise that the owner of the land has with that land certain rights, and those rights are really granted by the regulations that you pass. And look, I've been to these meetings over the years. If you have 40 people in the room saying this is the worst possible project on earth, don't you dare approve it, or it'll ruin my neighborhood, it'll ruin my property value.
The environment.
Well, the environment's a different issue, but if in fact that proposal is a site plan approval application and it meets the requirements, you lack the authority to turn it down. Doesn't matter how many people are in the room. And their recourse, of course, is, butters can appeal the approval, or the applicant can appeal the denial. But your role is to apply the applications, apply your regulations to that application. Special permit gives you more ability to look at this use on this land in that neighborhood and decide whether or not it meets the regulations. But the land use court in Hartford has gotten very wary of labeling things as special permits that are in fact site plan criteria. When I mentioned, not within, doesn't match the character of the neighborhood. That is so subjective. You can make anything not negative. Depends on your subjective view. Now, the environmental issue, environment considerations are outside your jurisdiction as a zoning commission. If there are wetlands present on the site, then that's your wetlands agency that has to consider that. That is, the people in the audience normally are not thrilled to hear that. But again, your authority to take any action is based on Connecticut law. And the best you can do is to, I think, take the action that you need to take and then inform people of their own appeal rights. As uneasy as that makes your neighbors feel sometimes, it really is your duty as a commission.
Now, could that fall under public health and safety? And-
Sure,
yeah.
if it does fall under public health and safety, but you can't recite public health and safety as a pretext to deny an application when there actually is no, in fact, public health and safety issue. And commissions and the regulations will stretch that public safety criteria very broadly. Trying to think of an example. A lot of times, especially in central Connecticut, there's a lot of development activity around warehouses, logistics centers, which is a nice name for a warehouse. And, that's why it's so important to focus on your plan of conservation and development and your zoning regulations, because if there's these transition zones, you got a neighborhood been there since the 1950s next to a farm. That farm is easily developed as a warehouse, especially if it's on the way to the airport or whatever. Your job in putting together your zoning regulations is to make sure you carefully craft your transitional zones. If nobody wants a warehouse, you've got to create a zone that doesn't allow warehouses. Otherwise, you're very likely to get it, and there's probably not a lot you can do. And, there'll be drainage studies and traffic studies and all these other studies you'll look at. And that's sometimes a way for a commission to deny an application if it doesn't meet your traffic standards or whatever. But can't stress enough, and I'm sure Shannon tells you all the time, it's very important to carefully draft your zoning regulations for that reason. Any other questions on that? The main point is you can only go so far applying your regulations, especially when it comes to site plans. Next slide. Zoning officer requirement. There's a recent update to General Statutes 8-3. Beginning 2 years ago, it was required that each person newly appointed as a zoning enforcement officer shall obtain a certificate from the Connecticut Association of Zoning Enforcement Officials, obtain such certification during the duration of their employment. I'm sure that's not a problem here.
Garrett's certified.
Garrett's certified. So, but there's a lot of towns where the zoning enforcement officer also acts as all kinds of different jobs around town hall. They really often do not know how to apply the rules of their position. Next slide. Now, this really occurred in 2 years ago. There was a major rewrite of General Statutes 8-2, and it was a good rewrite. 8-2 is the statute that defines the roles and responsibilities of the zoning commission. It enables you to pass your regulations, and it has a lot of verbiage about what you can and cannot do. It's all found in General Statute 8-2. The old version was just very long paragraph with no punctuation that looks like James Joyce wrote it, and it was nearly impossible to read and interpret. In 2023, the legislature broke it up into what zoning regulations can allow and what they can't allow. And this is just an excerpt from that. Now, zoning regulations shall not prohibit the operation in a residential zone of any family child care home or group care home located in a residence, or requiring a special permit for the operation of such home. This is an example of what I was talking about earlier of the legislature becoming more and more active in the area of dictating what towns can and cannot do in the zoning regulations. And obviously there is a very strong public policy issue in this particular regulation to try to do something about family child care and group child care and create more opportunity to run them in the home setting. So it's got to be as of right, and you can't require a special zoning permit or a special exception for such operation. There's a number of places where the legislature did this, prohibiting the use from becoming a special permit use. because in the minds of many, including the court, the special permit power has been too broadly used. Too many site plan applications have been turned into special permit applications simply by placing language into the zoning regulations. Next slide, please. Special permits approval requires that the proposed use according to the zoning regulations, according to the standards in the regulations, are satisfied conditions necessary for the protection of public health, safety, convenience, property values as established. That's the first time you see the word property values as something you can consider under a special permit power. As I said before, special site plan review is limited to whether or not a particular plan conforms to the regulations.
Bob, are there definitions in the statutes for public health, safety, convenience?
No, absolutely. not. Good question. Good question.
Okay.
But public health and safety is, there are many court cases that discuss it. And it's sort of like pornography. The definition is, you know it when you see it. Public health and safety is, a good example is you've got a traffic study that looks like the phone book that says no diminution of the level of service at this traffic light. It was F, it's staying in F. Therefore, we can build our gas station or whatever. And then you've got 50 people in the room that say, I live there, and I can tell you, it's horrible now. It's going to be worse afterwards. Public health and safety, in terms of traffic problems, is an area of public health and safety. Well, what the courts say is, well, it's good to hear from the public, but if the traffic engineer says it's not going to be any worse, unless there's a competing traffic study that says it will be worse, either from a hired third party or from your own staff, you've got to rely on the expert testimony that you hear.
To that point, when do commissions do as you just described, which is hire their own consultants? Because obviously there's potential conflicts of interest when the applicants hire all the experts, and
Oh, sure.
most of us are not the experts,
Yeah.
and we're supposed to make these determinations. So it always struck me as sort of odd that process is sort of is the way it
Yeah.
is.
On larger projects, it's pretty common. And Shannon, I think we've had that, haven't we?
We have a handful of times. It's been a while since we have, given we've got myself and Russ and Bruce as engineers in the office. So we don't very frequently have to do that.
Yeah, it's expensive and
Well, and the trick is the timing.
the timing is
So
a big
it's
issue.
very difficult with the statutory times
Right.
in order to get the application, the commission see it, the commission decide they want a third-party review. And then we've got to go on pause, right? To then go and solicit to RFPs
Yeah.
to somebody and to an engineer, try to find an engineer or scientist or
Sure.
whomever, technical person that is not on the land use end, that is willing to provide that third party that doesn't have a conflict of interest and can report back in the time frame that's needed under the statutory
Right.
timeframes.
What is that time frame? Like,
So we're coming up to it, but it's 65 days to hold a hearing. To 65, from the time the application is received to the time the hearing's open, we have 65 days. You have then 35 days to have the hearing open. You have 65 days to make a decision. You have 65 days of float time to extend any one of those periods, presuming the applicant consents to the extension.
Right. So essentially you have 180 days plus a 65-day bank of extensions. And that sounds like a lot. But for a larger project where you're going to hire your own traffic engineer or storm drainage engineer.
Yep.
It really, as Shannon points out, you can't, these are, reports are expensive.
Yeah.
And the town just can't go out and hire a $50,000
Yep.
engineer without going through some procurement process.
Well, right. Well, and typically there is a provision in the regulations that the applicant pay for the third-party review. But again, there needs to be no conflict of interest. And we still need to try to get 2 or 3 bids of whatever service that we are looking for.
But you do here, you do have staff that can expertly comment on the third-party reviewers that the applicant brings in. And the courts will honor that.
Thank you.
Next slide.
Yes.
Nope, back one, please.
Oh, yeah, okay. We're here.
Okay, we covered that.
Yep.
Oh, wait a minute, a couple points here. If the site plan does not conform in a minor correctable way, commission may modify the plan and approve. In other words, you don't have to just accept what's put in front of you. You can negotiate with the applicant, and you've done this probably in every application. Say, well, if you move those 4 parking spaces away from the, the front of the building, put them in the back, that type of thing is perfectly allowable. And you're required by statute to record or transcribe public hearings, usually record them. And then if there's an appeal, we'll get them transcribed because the appeal requires it. This is a new law, DMV location use approvals, moved from the ZBA to the zoning enforcement official. It's a really minor issue. Dealing in repairing of motor vehicles shall obtain and present to the commission with a certificate of approval to the CEO. It's to be the zoning board of appeals, which is very cumbersome in a lot of cases because ZBA doesn't meets every month. Doesn't always meet unless there's an application. Next slide, please. Now we turn to the planning commission, and as in this, you have both of these roles, and they're very different, as you probably know. But the planning commission's role is limited to these actions: adoptive conservation, plan of conservation and development, capital P, capital C, capital D. Different than the comprehensive plan, which we can talk about. Act on subdivision, amend subdivision regulations, adopt and amend subdivision regulations, act on those regulations, and also to pass judgment on municipal improvements under 8-26. The town wants to build a new school, of course, it comes to the planning commission, and you have to issue an 8-26 report. So in action regarding the plan of conservation development and the adoption of subdivision regulations are legislative acts. Action on subdivision applications are administrative acts. And you see this a lot, where someone plans let's use a 3-lot subdivision as an example. And there's a lot of opposition to it for lots of reasons. Maybe there's a historic house that needs to be torn down for the new subdivision. And the room will be filled with people who tell you that you can't possibly approve this. There's going to be all this damage to historic assets. You hear the arguments. But the fact is, if that subdivision proposal, subdivision plan complies with your subdivision regulations, it's an administrative action. And you have very little discretion as to whether to approve it or not. You can ask for changes, revisions, but whether it gets approved or not, if it meets the subdivision regulations, the courts are very strict on this one. must be approved. In the example I used, we spent a year on that one. maybe?
Yes, sir.
But at the end of the day, we prevailed because this commission applied the regulations after a lot of hearing and a lot of testimony and a lot of expert testimony. You did what the regulations required.
So Bob, you're basically saying, take the emotion out of it. Whether your emotions like it or not, if it meets the criteria, we're kind of bound to accept.
Yeah, I think that's true. I think because again, we're dealing with people's property rights. And if I own a piece of land and if I buy that land based on, I read the regulations and I say, hey, I think I can get 3 lots here. And the engineer says, well, you sure can. You meet all the regulations. You are obligated to apply your regulations. If the regulations aren't working in a way that you believe is good for the town, then you have the opportunity to change the regulations in ways that make it more comfortable for you. But when I come in with my application for a 3-lot subdivision, I read the regulations. I'm entitled to review based on what you've already put in place.
What would the process for reviewing regulations be in that case?
Well, it wouldn't apply to a filed application.
Right.
But it would be simply instructing staff to come up with a regulation amendment, text amendment in this case, because it would be the subdivision regulations. On the zoning side, you have text amendments and map amendments. You can change both. Change the text, allow something that's not allowed, disallow something that is allowed, and map amendment, expand, and you've done a lot of these over the years. Special area districts, land area districts. We've got a lot of different special regulations, which are both map amendments and text amendments.
And the subdivision regulations, there's fairly limited, unless we were going to start taking a look at each zone and look at the bulk regulation. The subdivision regulation itself is fairly prescriptive within the statute, correct?
That's correct. Within the subdivision regulations, though, you do have some latitude. But
Yeah, for like sidewalks and
yeah,
some buffer, but it's the bulk requirements of what you're looking at for lot lines and setbacks, and et cetera.
right.
Thank you.
So on the plan of conservation and development, you do have the planning commission has a lot of latitude to, and as you know, it has to be updated must be updated every 10 years, but of course you can amend it as often as you feel it's important to amend it. You don't have to wait 10 years to amend your plan of conservation and development. It's a very, very important tool because when you talk about acquisition of open space, you talk about preservation of environmental areas, it all should be captured in the plan of conservation and development because that's the foundation of your zoning regulations. Because anytime you change a zoning regulation, you have to make a finding that it's consistent with the plan of conservation and development. Next slide. Zoning Board of Appeals is the role is to protect the interests of individual property owners by granting variances during zoning enforcement appeals. The Zoning Board of Appeals and only the Zoning Board of Appeals has the right to vary the application of your zoning regulations to a particular site. Years ago, there was the McKenzie decision, Connecticut Superior Court decision. Lots of regulations in Connecticut, zoning regulations, had language that allowed the zoning commission to waive certain aspects of the regulation if they found it in the best interest of the town. For instance, zoning regulations would require 1 parking space for every 5,000 square feet or whatever it is of office, or 2,000 square feet. But on a particular site, they'd say, well, it makes sense to relax that a little bit. We're going to waive that. Well, in McKenzie, the court said, oh, no, you don't. You have no authority to waive your regulations only the zoning board of appeals can do that. They act in administrative quasi judicial capacity regarding variance applications and zoning appeals. An application requires 4 affirmative votes out of the 5 members of the ZBA to pass. And if someone is absent and there's only 4 sitting members, the applicant does have the right to say, hey, I'll see you next month. I don't want to have a unanimous vote. I'm entitled to have a full commission on that. The other thing about variances is issue of hardship. Do we have that in the next slide? Yes, standards for variance approval. No substantial effect on the comprehensive zone, and adherence to the regulations would create unusual hardship. That term unusual hardship is very difficult to, that standard is very difficult to meet because the hardship has to arise from the nature of the land itself. You often get what I call the pools, decks, and sheds variance application, where someone's owned their home for 40 years. They want to put a deck in, but they don't have the room to put it in as big as they want because it encroaches on the side yard. And there's a 20-foot side yard requirement, and the deck goes 3 feet into that, meaning there's only 17 feet instead of 20 feet. And they claim a hardship. And there's nobody in the room. The neighbors don't come out and say, don't you dare allow that 3 foot. You know, in fact, the neighbors will come in often and say, hey, Joe and Mary have been great neighbors. We often sit on their deck. Please let them have a larger deck. And zoning board of appeals and others looks at each other and says, oh, I guess it's a hardship. It's not really a hardship. And if someone were to appeal that, they would probably win that appeal. So hardship is a very high standard to meet. There's effectively no de minimis hardship law in Connecticut. Lots of states will say, well, you know, if it's a de minimis intrusion on the requirement, then you're allowed to pass it. Not in Connecticut. And the first prong is usually pretty easy to meet, standard, no effect on a comprehensive plan. But the second one, the unusual hardship, is difficult. I'll give you an example of unusual hardship. If you have a lot and you want to build that same deck and you've got shale in your yard such that you can't possibly build where you could build and meet the regulations, and the only place to build encroaches, because that condition arises from the nature of the land, you probably could support a claim for hardship. The other principle is used to get a lot of applications for variances for signs. Everybody wants a bigger sign, not a smaller sign. And the rule and the law in Connecticut is no such thing as a sign hardship, unless, again, you can only place it in one place and there's some sort of condition of the land that doesn't allow you to put it there. And here the board is required to record or transcribe the proceedings. Any questions?
Bob, I kind of have one again.
Sure.
It might sound a little stupid, but going back to what you were saying before, just asking for if there's a definition or not. Can people define best interest of the town?
No,
No.
because your definition of best interest of the town may be wildly different than your neighbor's
Right.
best interest of the town. And those sorts of subjective criteria are ripe for the court to overturn a decision because it's a standardless standard. There's no best interest of the town. There's no standard for in keeping with the community, the character of the community, because those type of standards allow, if they were upheld, would allow commissions to make all kinds of subjective judgments that would potentially intrude on someone's constitutional rights. And the great thing about land use law and municipal law generally is it all springs from constitutional law. You can't take something away from somebody in this country without due process of law, as I said. And there's the other clause we always hear about, equal protection. The equal protection clause essentially means that all residents of your community have the right to be treated equally. So courts are wary of standards that say best interest of the town and all of that. And increasingly so.
Yeah, I was just curious in case, I'm sure it happens all the time where people try to argue increase property values, best interest of the town, overall look, best interest of the town, that kind of
Yeah.
thing. So, gotcha.
You'll often hear statements, I've lived here 40 years, it's a beautiful town, and it is. And this proposal will destroy the character of our community we've worked so hard and spent so much money to protect. But those are, I think there are ways to approach those issues with standards that aren't subjective. And I think knowing your regulations the way I do, you've done a pretty good job of that. There are requirements in the physical development of land that you can put in place that aren't subjective that will address those issues. Setbacks from the road and landscaping requirements, and signage requirements. Those are all allowable as long as they're objective. Inland Wetlands Agency. Inland Wetlands Agency is different than the Planning, Zoning, and ZBA in this regard. The local Inland Wetlands Agency is really the agent for the state of Connecticut, much like the Board of Education is the agent for the state of Connecticut, because the Connecticut Inland Wetlands Law is not that old, dates back to the early 70s. A guy like me, that's not so long ago. And the authority to regulate wetlands in an individual town is delegated to the town, which may establish an inland wetlands agency to do so. And it's to adopt regulations to protect the wetlands and water courses and act on application for a permit for any proposed regulated activity. Got the source of authority. Again, acts legislatively when amending regulations and administratively when acting on an application. And the easiest way to understand the role of the Inland Wetlands Agency is two things: regulated activity within a regulated area. It's those two things. And the regulated activity is defined in the regulations, and the regulated area is defined on a map or anywhere where there is the presence of wetland soils. Right, Shannon? We deal with that once in a while.
We do.
Yeah.
Yes, sir.
And
Yeah.
which controls? It's the actual character of the soils that controls, not the map. We've dealt with that.
Yes.
We've had some interesting issues in those wetlands. Any questions on inland wetlands? But the Inland Wetlands Agency does deal with environmental issues, and it's the consideration and review of a wetlands application usually is based not on like just traffic studies and stormwater studies, but also more environmentally focused studies about the character of the land and the impact of the proposed development on the regulated area. And there's a whole lot to that we don't have time for tonight, but it's very complicated. Next slide. Conservation Commission. Develop conservation, supervision, and regulation of natural resources, including water resources. And that's found in 7-131A. It sort of looks like what the Wetlands Agency does, so that's why many towns put them together. But they're really two different actions. If you need a Conservation Commission permit, it's a separate action. Next slide, please. And these are the specific powers. propose greenways plans, take inventory of natural resources, keep an index of all open areas, may recommend to the planning commission plans and programs for development of such areas, make recommendations to zoning, planning, and wetland proposed land use changes. Now, the Conservation Commission is one of the primary resources you use, Planning Commission uses in developing the plan of conservation and development. And technically, the town should have an open space plan developed by the Conservation Commission. And it's that plan that gets included in your POCD as your open space plan. It's really the Conservation Commission that is charged with the responsibility for creating and maintaining an inventory of open space areas. And open space area should not be confused with vacant land area. They're two different things. And designation of open space areas by the Conservation Commission and included in the Plan of Conservation Commission, Plan of Conservation Development, triggers the PA 490 tax incentives. And it's not just PA 490, there's a host of tax incentives for farmland and open space, but it's got to be included in the POCD before it's eligible for that. Technically, lots of towns don't.
Bob, we've got a hand raised, our chair, we've got a bunch of members
Oh,
from
okay.
our
Sure.
Inland Wetlands Commission on, so.
Oh, hello.
Ned, you should
Hi.
be able to. unmute.
Yeah.
Yep.
I heard you use the term conservation permit. I don't think we've ever acted on a conservation permit in town. So I've been on the Inland Wetlands and Conservation a long time. And I don't remember
No, I
hearing acting on a
I don't think there is a-
conservation permit.
Yeah, I think that's a typo in my presentation. It's a Conservation report, Commission report.
Oh.
You're right, there aren't permits. It's not
Okay.
a regulatory agency. So you've been doing it right all along.
Yeah, we've received reports on occasion from Concom on planning on subdivisions and frequently to town council if there's a consideration for a land purchase or a modification to a conservation easement.
Yeah.
Are probably the more frequent items that have come before the Conservation Commission.
Right, especially the acquisition or disposition of any land, town-owned land.
Yeah, it's been the acquisition. We don't very often dispose of, but for any of the acquisitions.
Right.
It's got a Conservation Commission referral and report.
Yeah, because what the Conservation Commission does is they make an assessment of the functions and values of the land for open space purposes. And a good example of a function and value would be whether it's adjacent to existing open space, whether it starts or completes a wildlife corridor. Again, it's not just vacant land, it has a value over and above the fact that there's no building on it. Next slide.
Bob, sorry, just real quick. You said it's not vacant land. So the difference between vacant land and open space is it has to have value?
No, the reason I raise that as a distinction is not every piece of vacant land owned by the town is necessarily open space, because it hasn't been designated as open space. It hasn't been assessed, and it's not managed as open space. It's just, you can take your vacant land and turn it into open space, designating it, but in and of itself. And this comes up a lot in subdivisions where subdivisions approved in 1916, there's a little stub of land that is left open because the anticipation is you're going to build a road to the next phase. Next phase never gets built. And there's this piece of land, usually deeded to the town, that's just there. The other way it comes up is in subdivisions, there's usually what's called an open space dedication. Now that would be open space, but there's other areas around town where vacant land owned by the town may or may not have a value as open space.
The requirements to maintain open space in some way?
There are no
Or it's
requirements
It
to
just has to be designated that.
Yeah, designated.
So once it's blessed, it's
Yeah,
as open
usually
space, it's open space.
the way we do it now is we get a conservation easement that spells out exactly what you can and cannot do on that land. Once a conservation easement's in place, should be designated as open space within your inventory. But with no conservation easement, the fact that it's just, nothing's built on it, does not necessarily classify it as open space.
Thank you.
Specific powers you see here, acquire land and easements, supervise and manage municipally open space or park property. These are the powers that Conservation Commission may exercise in most towns. They don't go as far as, so keep records of its meetings, make an annual report to the municipality, receive gifts in the name of the municipality, and for any purposes, administer the same. This list comes out of the statute empowering conservation commissions. Next slide, please. Now we get into a little bit more specificity about legislative and administrative actions. General rules regarding acting on an application and improper actions or participation by commission members. These are the next topics we're going to pick up next. I think we covered this already, but just to reiterate, commission has greater discretion when acting in a legislative capacity and then when performing administrative functions. Legislative actions generally are held as long as it's within the legislative authority. That last part is very important. You have to have the authority to begin with to take the legislative action. For instance, you could not include in your zoning regulations coverage of a piece of land in a neighboring town. It's an absurd example. But, basic role and function, administrative actions is determine whether the application conforms to existing regulations. We've already talked about that. Next slide, please. Now, these are some general rules we put together when acting on an application. Most applications require public hearings, publication of 2 legal notices. Site plans do not require public hearings. You can have a public hearing on a site plan if you vote to do so, but it's not required. And you can't be compelled to hold a public hearing on a site plan application. But sometimes you have a site plan, it's a big one, you know, big project, and you get a whole lot of your friends and neighbors come in and say, we want to say something about this. Well, they can't say it that night because it wasn't noticed at the public hearing, but you could hold a public hearing and say, well, you want to say it, we want to hear it. This is a big project. So you have that authority. Proper legal notice is mandatory for an agency to have jurisdiction over an application. These notice requirements are strictly construed by the courts. If you miss them, the court will overturn your approval. Procedural issues are where you're most vulnerable on appeal. That's why we have sleepless nights, Shannon, to make sure all of that stuff gets done the way it should get done. Public hearings must be scheduled within the statutory time limits. We talked a little bit about that earlier. And it must be completed within the statutory time limit. The decision must be rendered. If it's not an application that requires a public hearing, you have 5 days to act on the application. But there's that 65-day period of extensions, which the applicant needs to consent to. There's very few applicants who won't consent to it because they say, we're not consenting. We want you to act tonight. You shrug and say, well, okay, you will act. Well, we're going to deny it because it's incomplete. So they always say, oh, sure, you can have more time. The notice of decision must be published within the time limits. And the applicant has 15 days to appeal from zoning board of appeals. That's 15 days from the publication of the notice of the decision. Usually takes 5 days to get into a paper, so it's roughly 20 days. And that's it. There's no, a late appeal will get dismissed. If the town brings the motion to dismiss it. Doesn't happen that often, but it does occasionally happen. Next slide. Here's our timeframes again that we already talked about. Talked about 15 days. Next slide. Okay, improper actions or participation by members of the commission. Insufficient participation in the application to decide fairly, the member must be sufficiently acquainted with the issues, evidence, and arguments in order to vote on it. Now, a lot of times, a member, some of these applications go on for 2, 3, 4 sessions of the commission, and a member will miss a session or 2 sessions. That doesn't mean the member can't vote. What that means is the member has to take the time to sufficiently acquaint themselves with what happened at that meeting and state on the record, I was at the last meeting, but I've taken the time working with staff to acquaint myself with the proceedings of the commission, and I feel I'm adequately acquainted with it to proceed. If that statement's on the record, it's not likely that a court's going to say, well, how much time did you spend? You know, they're not going to look beyond that, but you have to make the statement. That's what the member who missed may listen to the tape. That's how you appoint yourself. Listen to the tape. You can't just read the minutes, because that's not going to be adequate participation, adequately. Improper participation by commission or participation by predetermination. This is a big one. The issue is whether the member is so close-minded that the mind was made up prior to the public hearing. Presumption is that members are unbiased and act properly, heavy burden on the claimant. Now, this deserves a little bit of attention. If you hear the application, you're in a public hearing, and a member of the commission were to say something along the lines of, you know, I live right around the corner from this site. I'll never approve this application because it's going to affect my drive home. Obviously, that's an absurd example. That member has predetermination. If that's in the record, and if it's a material vote to pass or reject it, that could be overturned. Or even if it's not material, the court may say that that statement so tainted the consideration of the application that it was tainted by predetermination of bias. Now, predetermination and bias are very easy to allege, very difficult to prove. It is okay for you to say, I'm very familiar with that site, and I have, based on my familiarity, I have a number of questions that I will raise during this public hearing that I would like you to respond to. That's not predetermination, that's doing your job. If you say, you know, flat out, I just don't want a car dealership next to my house and I'll never vote for your application, that's not a good way to state that. But if you say, you know, I have serious concerns and I'd like you to address these concerns, that's the difference between predetermination and doing your job. The claimant can present evidence regarding remarks made prior to the public hearing regarding the application. Ex parte remarks, these are what I call the supermarket remarks. You're in the supermarket, everybody knows who you are because you're public officials. Somebody stops you in the aisle and says, oh, glad I ran into you. I hope you feel the way I do about that application. That's the worst thing that would ever happen to this town. And the only response you should make is, well, thank you very much for sharing your concerns. However, you need to come to the next meeting and speak at the public hearing. If you're in that supermarket and say, oh, I know, I can't wait to turn that one down, and that remark finds its way into the record by the applicant, that's that could be fatal to the application, to your action.
I have a question.
Yeah, we've got a,
What about social media? I mean, that's the new,
Good,
I mean,
good question.
that can help with predetermining or determine predetermination, can it?
It sure can if the social media entry posting, I'm not too good with the terms on this stuff, but comes from a commission member, then it's like the remarks in the supermarket, only easier to prove because there it is in black and white. you know, we had the hearing last night. That was the worst proposal I've ever seen. I can't wait to vote that one down. You post that on social media, yeah, you probably shouldn't be on the commission, to be honest with you. But if not members of the commission, but other publicly involved people, they're free to say whatever they want to say on social media. Caution the legislative body for saying those things, because someone could claim that by virtue of their role as the legislative body in the town council, they would have undue influence merely by being part of the legislative body. But the countervailing value here is free speech and a public official's right and responsibility to let their constituents know how they're thinking about things. So it's like most things, it's a balance. I run into this quite a bit in towns I've represented over the years. First selectman would say, you know, I really don't like that proposal for such and such piece of land. And I always say, well, is it an active application in front of you? Oh yeah, but you know, people want me to take a stand. I said, well, you can take a stand, but how you do that's important. If you go to that public hearing and you speak as a resident and speak as an interested individual, it's probably okay, probably part of your job. But if you stay up late at night making phone calls to commission members, that's probably not okay. So again, it's due process, it's equal protection. It's if you're a public official, elected official, or appointed official, and you have an opinion about something, the applicant has the right to hear it in the public hearing session, because that gives the applicant, the owner of the land, the right to say something about it or to give the contrary view. If you do it at night on the phone or at social media, that denies the applicant of their right to respond. And that's where you run into trouble. So predetermination is a very, very big issue.
Hey, Bob.
Yes.
Can I ask a specific follow-up to this
Sure.
part of the discussion? So, as a member of the commission, if I were to post on social media, just announcing, advertising, publicizing that an application is pending, been received, or a public hearing is coming, for this commission, or even for inland wetlands, because often in the wetlands that comes to TPZ, completely factual, link to the planner's website with all the documentation. Here's the date and time of the meeting. No comment whatsoever from myself. Is that considered
Perfectly allowable.
Okay.
Probably part of your job.
Okay. Thank you.
As long as you avoid what's called words of advocacy.
Right.
If you say, hey, this is a big proposal, I've heard from a lot of my neighbors, we have the hearing next week, we'd love for you to come down and tell us how you think. Nothing wrong with that. If you go beyond that by saying, I've heard from my neighbors, I agree with them, you know, then
Understood.
you get into a difficult area.
Makes sense. Thank you.
Yep. So we've covered predetermination. Now we're going to cover improper actions or participation by commission members, conflict of interest. And zoning and planning each have a statute that covers this. 811 and 821 regulations cover it. Ethics, ethics codes cover it. Everybody covers this issue, which is a member may not participate in any decision which he or she has a direct or indirect personal financial interest. The law in Connecticut is very, very strict on this, personal or financial interest. The obvious example, the applicant's here presenting an application, and a family member of a commission member owns that piece of land. You got to recuse yourself. And recusal, this is another thing. Recusal doesn't mean, hey, you do it at the end of the public hearing. You do it up front. Say, I'm recusing myself due to a potential conflict of interest, and you have to leave the room. You can't sit in the audience. You can't sit at the dais here and, you know, make expressions to your fellow commission members. And these are all come out of cases that have dealt with this. You have to leave the room during the consideration and action. A lot of people think you don't have to leave the room for consideration, but you do. Recusal means you're not even here, and you having no input on this application. Personal interest in the subject matter, relationship with a party that impairs impartiality. You're all volunteers, you have day jobs. If you're a bank president and you're considering a loan for this application, and if the application goes through, you make that loan and the bank makes money, that's enough to create a personal interest. If you're an employee, if you're a bank teller in that same bank, probably not, because whether this loan goes through or not, it's not going to have any impact on your financial situation. Still a little close, though. I would, if you know about the loan, it's probably a good idea.
So, just,
Yes,
because it's a small town. We all seem to know each other.
sure.
So I run into somebody that I play indoor soccer with, or my kids graduate with them. You know, we don't go to dinner, we don't do any of that, but we're friendly with each other
Sure.
due to the kids. Is there any conflict with them standing in front of us as long as there's no vested interest in it?
I don't think so, because the courts have said, hey, look, these are all volunteers commissions. You all play a lot of different roles in the community. You all have jobs, you all have friends, you all have neighbors. You're here because of that. If you think about it, you're here because you have knowledge of the community and you know people in the community and you represent the community's interests. So I wouldn't say, hey, I coached soccer with that person 10 years ago or even 6 months ago is enough. When it goes beyond that, and the arbiter of that is really the commission itself. If you raise that issue, say, hey, commission, I just want to let everybody know this is what's going on, and put it to you. The commission members themselves can say, yeah, I'm not comfortable with you participating, or we've heard it all and we're okay with that. As long as that's in the record, I can't see a court saying, oh no, that was improper. So long as it's that sort of thing.
Gotcha.
When you're making money as a result of the application, or your compensation at work is impacted, or it's a direct family member, then you got to walk. Now, what about the applicant that's involving a parcel of land that's around the corner from you? Is that too close? It depends. It all depends on how close it is and whether it'll impact your life. If it's that big old warehouse and it faces your backyard, you probably want to recuse yourself. If it's 2 streets away, maybe not.
Bob, are there any restrictions on having done business with the applicant in the past? So maybe you've accepted money for services
Sometimes there is.
in the past.
Sometimes there is. Depends on the factual circumstance.
Okay.
Real estate agents, insurance brokers, people who have run community businesses that rely on accountants, lawyers. If you're a lawyer on the commission and the applicant is a client or former client, you probably got to take a walk. Because again, it's that relationship that could potentially bias your decision making.
Thanks.
This is whether personal interest reasonably might conflict. Actual conflict not needed. And this is where Connecticut is slightly different, I think. The appearance of impropriety that undermines the public confidence requires disqualification. That's the magic phrase in the cases. Appearance of that undermines the public confidence. Especially these days where there's conspiracies for everything. When in doubt, recuse yourself. It's not good for anybody. Disqualified not only meet from the vote, but also participate in hearing, discussion. We already talked about that. A lot of people think you can participate in the vote, ask questions, be a full participant in the commission, and at the last minute say, I got to recuse myself. That doesn't work. If you have any questions about it, give Shannon a call. You're here of an application, or you have one of these informal meetings that we talked about earlier, and you say, it's not something about this I'm not comfortable with. Call Shannon. Shannon calls me. We talk about it. We discuss it, Shannon and I, and we'll give you advice. And then you can say, I called town staff, she called town attorney, and, we had a full discussion on it. And that's always good to have in the record. Then you can,
Mr.
then you can blame the,
Bob, we've got another hand raised.
okay.
I refer to you as Mr. Barry, you're not the chair. Now, go ahead.
Yeah, just one more case. Like somebody who's been working on your car regularly last 5, 10 years, and now he comes before you with an application. Would you recuse yourself, or if it's just a regular business, that's where you get your car fixed? Would that still be a conflict or not?
Off the top of my head, I don't think so. If you have a service contract with him or her, where you have a fleet of vehicles, but if you're just someone who goes to that a shop because you think they do a good job and they charge you market rate like everyone else, and you have no anticipation you'll have to go back anytime soon, but knowing cars the way they are, you probably will. But if you don't anticipate you're going to be back in that shop during the pendency of the application, I think you'll be okay.
Okay.
But again, that's one we'd like to talk about and really nail down the facts. Because again, it can't be so restrictive that nobody on the commission can live their lives in Farmington.
Right.
So, any other questions? Tricky area.
Like next door neighbors, neighbors down the street, sort of thing. That's the other one.
Next door neighbor, I think as long as you can show that there's no relationship now you can be friendly with your neighbor, but it all depends on the nature of that relationship. A lot of us have neighbors that we wave to in the morning on the way to work, and
Cordial.
Yeah, cordial.
Hi.
But if you go on vacations together, if your kids are in each other's weddings, that makes a difference, I think, because you'll be inclined. It's human nature. You'd be inclined to want to help your friend.
Current and former employers.
Why are they your former employer?
Say you leave. Yeah, that's a great point. Yeah.
Current employer, recuse yourself.
Yeah.
Former employer, again, unless there's some sort of animus against that person because they really did you wrong, it's probably okay.
Seems tricky because you could really like them too after.
Yeah.
Yeah.
But again, your action on the commission, it's former employer, your action on the commission is not likely to accrue to your benefit one way or the other if you're a former employer.
Right.
If you're present, if your boss is in front of you, though, again, appearance of impropriety.
Yep.
Is the standard. Okay, consideration of evidence after close of public hearing. This comes up quite a bit. You've gone through your public hearing. You've said, anybody have anything else to say? And the reports are all in. You close the public hearing. The applicant comes back and says, oh, gee, I forgot to give you this report that says what a great job we're doing with traffic. Shannon will tell them, not going to happen. So they'll come to the commission and say, hey, Shannon said no. You can't consider anything that's not part of the public hearing record. Can't reopen the public hearing record. Because you renotice it, you just don't do that. And importantly, the opposing side is entitled to time to rebut anything that comes into evidence in your file. If the opposition group comes in and they come in at the last minute, and it happens more times than it should, they don't tell anybody, but the last minute, the last day of the public hearing, they sure enough come up with their own traffic report. No one's ever seen it before. And the applicant says, where did this come from? I've never seen this. You can't say, well, listen, we're closing tonight, read it in the hallway if you want. That's not going to work. You've got to give the opposing party on either side time. If you accept that report, and if it comes in during the public hearing, you probably have to, you've got to extend and give time. Now, what if you're on your last day? It's reasonable for you to say, too late. Shannon told you you had to have this in 2 weeks ago, and you waited till tonight. I'm sorry. We're not going to consider it. That's probably the way to handle that.
Bob, what about cases where, so generally, in my experience with public hearings here, there's a public comment period at some point.
Mhm.
I forget, honestly, if it's before or after. It's probably, I guess it's after the applicant makes their initial presentation, but
Yes.
there's often discussion afterwards.
Yes.
And new facts come up, and sometimes the applicant is asked to make statements or make changes to the application. But sort of public comment seems to be a one and done opportunity.
Mhm.
And if it's the last day, if it's a 1 day public hearing, or it seems like, and I guess I'm trying to understand, to your point, like does the public have a right to interject outside of the officially designated public comment period when sort of new information may have been discussed or presented? Because in my experience in the past, that generally there's not an opportunity for that.
Generally, yes. The general rule is if something new comes before the commission, either through the applicant or through the group that doesn't like the application, the other side has to have an opportunity to react to that new information. You may say, I'm not really convinced on that drainage study. I'd like to take a couple more drainage pits or whatever. And they say, well, it's going to take us a couple weeks to do that. Okay, well, extend the public hearing. And we've had this. But what Shannon will tell them is you got to get it to us in time so the other side can see it and respond before the hearing reopens. And a lot of times they just don't do it, for whatever reason. If it's getting to be towards the end of the deadline, the final deadline, that raises an issue. But generally speaking, you should invite the public to comment on new information. Now, if they don't, then they don't. But
Sure.
the opportunity to.
I guess I'm thinking of this not necessarily like I'm going to go the applicant's going to go get more information, because in my experience, if there's another day of the public hearing at the next meeting, there's always another public comment period. I guess I'm talking about within a single day public hearing, there's one public comment period, but there is information that sometimes is presented, questions that are asked, more information revealed, sometimes agreements or suggestions made and the applicant agrees. And there's never like a go back to like, are there any further public comments after the, I don't know, deliberations, I guess, or whatever it would be called, the discussion that the commission has? Should that be something that we should do as a commission to sort of solicit public comment,
Well,
at the end,
what
I
do you
guess?
think,
or,
Shannon? I mean,
Well, so, and this goes back to how a trial, right? The applicant has the last right of
That's
comment.
true. Because
So,
the
and there is no
applicant,
standing, right? So yes, the public has comment, but there is no standing unless there's an intervener application.
yeah, that's a whole different set of rules.
Well, right. So, typically the typical neighborhood, unless they've filed a petition to intervene, they typically do not have their own traffic report or own
Right.
whatever. So again, there's the applicant presents, the commission asks questions, it's open to public comment. The applicant then responds to public comment. The commission has any follow-up, then that's the case. On occasion, if there's a hand raised in the gallery, then at the chair's discretion, additional comment is made. But again, the applicant has the right to closing, the
Their
last
present- yeah.
closing comment.
It's really up to the commission's discretion, because sometimes during that presentation, public comment, someone on the commission will say, I'm really troubled by this or that. The other thing, I'd like you to respond to that applicant, depending on what it is.
Yep.
It's reasonable for the chair to say, has anybody heard the response? Anyone have any final questions about that? And then give the applicant the opportunity to close out their presentation once and for all, because otherwise you go back and forth all night, I guess. But
Right.
I guess it's really commission discretion.
Okay, so it could be in the agenda twice. It could just be the chair's discretion or whatever,
Yeah,
or not at all. Okay, thank you.
comes up a lot on a controversial application. Now, again, to this issue of what improper actions after the close of the public hearing, the commission can always get the advice of their staff after the close of the public hearing, interpreting what's in the public hearing record. Commission has to look at the public hearing record, give you the benefit of their expert advice and what is in front of you. It's not proper for the staff to say, you know, we had a question about that too, so we went out and got our own expert and brought it in, and here's the expert's report. Because that's not in the public hearing record.
Can those, so how would that discussion happen practically? Because is that just with one-on-one with a commissioner and the staff? Or because if we then start having multiple commissioners, then does that become sort of a,
It's usually done through
Take
staff
communication.
report, right? That's the
Okay.
usual practice, is after the
Yeah,
public
it's done
hearing.
in the context, so depending on the complexity of the application, there have been applications where the hearing is closed and the commission requests staff to draft a decision, both an approval and denial, and kind of put together conditions that have been discussed, and outline the documents that have been included. A lot of the applications as of late have been more straightforward applications that have been addressed in one evening. And I'm going back a couple years when we had like months of meetings, application, which we haven't had in a little bit of time.
Yeah.
So it hasn't been necessary to do that, but that's how that would happen, is that staff would draft a decision, both the denial and the approval. And then the commission put it forth to the commission as part of the agenda review for the commission's consideration at a
Right.
subsequent meeting.
And
And it-
provide commentary on what the commission heard from the experts as well.
Right.
That is allowable.
so is it fair, just to summarize some of my understanding, which may not be correct, so correct me. But like, so once something's in an application, once an application's been, I guess, submitted, no commissioner should talk to another commissioner about that application. Is that a correct statement? Start with that.
That's a correct statement.
Correct. Outside of a meeting.
Yeah,
Outside
You've
of-
got
Right.
free reign to me.
Well, that was my next question was, can we talk to Shannon or her staff one-on-one, I guess, but not with another
You
commissioner?
should always talk to staff.
Okay.
So long as you're not creating a dialogue amongst the
Between
commission members based on what you hear from staff.
Yeah.
You always have staff at your disposal to help you understand and interpret the information you receive from the applicant or anyone opposing the application.
Typically, what I'll do is if I get a call or an email with a question from someone, one of the commissioners, then if it's prior to the agenda review release, then I will try to incorporate whatever that question and answer are into the agenda review. Or depending on its pertinence, into the email to the commission, so that everyone has the benefit of what the question was and what the answer was. So again, it kind of timing and whatnot, sometimes it's via email, sometimes it's right in the agenda review, sometimes it depends on the context of what's being asked as well.
Okay.
But yeah, so that happens frequently, that somebody needs a question regarding a piece of information that's part of the application.
Thank you both.
So if evidence does come in after the close of the public hearing, from whatever means, from whoever it comes from, it's a rebuttable presumption that that evidence was prejudicial, could form the basis of a negative action by the court. And like I said, it's fairly routine that either side will say, "Oh, I forgot," and staff has to say, "It's too late."
Yeah, we get that on occasion, more often from public wanting to add something in, and it can't be done at that.
Yeah,
particular
stack of letters, a petition, photographs.
Well, and quite honestly, a petition, all a petition does is request a hearing, which has already taken place.
Yep.
That was noticed, and so.
So tips. to members. My next one's making the record.
I'm doing this. Improper actions. No, I did improper actions. And then tips to commissions, and then making the record.
Okay.
So just the tip that we want it in the affirmative.
Yeah, it's sort of, always make a motion in affirmative. I move that we approve. I move that we deny, right? I mean, it's always got to be
Affirmative is helpful.
affirmative so that it's clear in the record that the commission members knew what they were voting on. I move we approve, that's pretty easy to understand. Move that we deny. Second, vote in favor of the motion to deny is to deny. Sounds, and then as long as the motion is clear in the record, you may all think you understand what it meant, but 6 months later, the judges, well, did you vote yes or no? Vote to approve that fails is a denial. A vote to deny that fails does not mean approval or denial. An important point. A vote to deny that fails does not mean it's approved. It's got to be an affirmative approval by a majority of the commission members. The contents of the record.
Do you want me to go right?
Yeah. Basically, everything in the file on that application is part of the record. And the way it works is you put together your list of documents in the record, you send it to opposing counsel, and you come to an agreement as to what's going to be made, put in the record on appeal. You know, because there's all kinds of stuff in here. There's minutes, there's agendas, there's, you know, the green card you send out with. A lot of that is not pertinent to the appeal as long as both sides approve it. And I never forget Judge Berger, who's head of the land use court for many, many years, sent us back 3 times saying, no, it's too much here. You know, I don't, you're giving me stuff I don't care about. So they really like, the courts really like you to narrow down that record and not have every scrap of paper that ever made it into a file. But it has to be these things. It has to be certainly the application, agency reports, legal notices, sometimes yes, sometimes no. A lot of times it's not an issue, don't put it in. Copies of all maps, transcripts, and the written decision. The reason for that is you're asking the judge, who has 20 of these cases, to reconstruct everything you did. And we're always working hard to uphold the decisions you make, and the cleaner the record, the clearer the record, the easier it is to do that. The judge has to go searching around, like, you said you approved it. I don't see anything that says that. The point is, and we don't have that problem here.
We've been pretty tight so far.
Yeah, pretty good, pretty good. We've never lost it. Have we lost anything?
No, sir.
We have not lost it.
We're not breaking that track.
You just,
We don't want to start now, so we got to have a good record. And the written decision should include the reasons for it and any conditions opposed. Another issue about those conditions, unless they're part of the written record, they're not enforceable. So you could approve that convenience store, and the approval, you could say, you know, I really like it to close by 10 o'clock at night every night. And the applicants can say, oh yeah, sure, we'll do that. But it doesn't make it into a condition of approval. Guess what happens? You drive by at midnight, the place is lit up like a Christmas tree. They can see it from the Space Center, the space shuttle, or whatever. You say, hey, I thought you were going to close by 10. Well, you know, we get most of our business now after 10, so we decided to stay open. And you go to Shannon and say, enforce that condition. And she's going to tell you, well, you didn't put, not a written condition. We can't enforce it.
We have put so the condition is as presented. So
Mhm.
as presented and agreed to during the meeting. To cover, would you agree? And that's how the word, so that we're not listing as we go through this every tweak back and forth.
No, you don't need every tweak, but if you
So-
want them, I would suggest that that's a good omnibus.
Catch all.
Getting in there, but the suspenders in a belt, if you want them closed by 10, that's a good,
Sure, so the more salient
more
ones.
salient ones. You know,
Understood.
no parking spaces in the front of the, whatever. Standard of review on a traditional appeal, next slide. the court on a standard traditional appeal, not a affordable housing appeal. The court's function is to review the record made by the agency. The appealing parties required martial evidence in the record to demonstrate that the evidence does not support proper support. The applicant, the appealing party, has the burden of demonstrating that the board acted improperly, because there is a presumption that you acted properly. And it's the applicant's, the appellant's burden to prove that you did not on a traditional appeal. And the court is going to look at whether or not the record supports the decision you made. It's that simple. Is it consistent with the regulations? Is there evidence in the record that supports your decision? Very, very difficult to overcome that burden of proof by an applicant if those two things are in place. Next slide, standard of traditional appeal, judicial review of legislative action. Again, is the decision reasonably supported by the record? If the agency has stated the reasons, the court determines whether reasons are reasonably supported, decisions upheld. If even one of the stated reasons is sufficient to support it. You may list 9 reasons for approving the text amendment, and the appellant may point out that 8 of those 9 reasons are totally bogus. As long as one is not, then the court will uphold the decision. And if the agent hasn't stated the reasons, and this happens, you say, okay, we've heard everything. Anyone want to take a vote? Yeah, I move to approve. Second. All in favor? Aye. No stated reasons. Under traditional appeal, the court has the obligation to search the record for support for that decision. Now, this commission's been pretty good. I mean, it's not hard to find the stated reasons from this commission, in my experience, having done quite a few. So keep doing that. Keep having good deliberations. Go around the dais and asking people to say not only yes or no, but why yes or no.
I have a question about
Sure.
that, actually. Would it be out of order to say, in my opinion, in that instance, or would you want to phrase it as such, like, given the evidence?
Yeah, you can say my opinion, but you always want to tie it back to the evidence.
Yeah.
In my opinion, the evidence that I heard supports an approval,
Gotcha.
because really your vote is based on your opinion and what you heard. So
Right.
There's no problem in saying that.
Gotcha.
And the administrative, judicial review of administrative actions, finding will be invalidated only if not supported by substantial evidence in the record. Evidence is sufficient if it affords a substantial basis of fact from which the fact in issue can be reasonably inferred. Very, very high bar to overcome that standard if you're challenging a decision on an administrative application. There has to be something in that record that just is so out of order that no reasonable person could have voted yes, basically. Or on a denial. I mean, same thing with denial. If you deny, not so much administrative, but some other application, the burden's the same. The appellant, in this case, the applicant, has to show that it's there's no basis in the record to support the denial. We'll go quickly through the next section, FOI, because I don't want to keep people too late. You're subject to the Freedom of Information Act, as you know. Next slide. Policy is open conduct of government and free public access to records. Connecticut has a very, very good Freedom of Information Act. Sometimes we don't like it, but we should like it because it's commission and the act itself are very, very strong and been around a while, and there's very clear rules. They really are. All meetings must be open. This is stuff you probably already know. Meetings including an assembly or quorum of the agency at which the discussion or action upon a matter takes place. Exceptions to that are social meetings either planned or intended for the purpose of discussing agency business. If you all end up at the same holiday party, it's not an illegal meeting because it wasn't called for the purpose of discussing. Now, when you all get together, it's normal and human and natural to talk shop, right? Just don't talk about pending applications. You'll be fine. Permissible subject for executive sessions. I think you're familiar with those. Do not include discussion on land use matters and most other matters that come before a land use agency. You cannot have an executive session to discuss that traffic report that you received on a controversial application. You can have an executive session to discuss the legal advice you get from your town attorney, as long as it's in writing and as long as it satisfies the attorney-client relationship. But you can't have an executive session. Let's get town attorney in here. We want to talk about the application with him. Improper. If you say, hey, town attorney, what about this legal issue we heard during the pendency of this application? Town attorney puts it in writing. It's that writing that can bring you to executive session, as long as that session is limited only to that legal advice. Can't shoehorn it into a discussion of the application. I think these are pretty standard provisions here. This online business is new as a result of COVID. Remote meeting versus in-person meetings. I had a long matter in another town on this. But I think we pretty much got it nailed down now. If it's noticed as a hybrid meeting, so-called hybrid meeting, the FOI changed the law to allow that. If it's not noticed as a hybrid meeting and someone calls in, it doesn't convert it to a hybrid meeting, which was an issue I had to confront with the commission. So the best practice is to put right on the agenda, in person or hybrid, either one, but let the world know that it's in person or it's hybrid. And we're going to be okay from that FOI perspective. Next slide. Well, affordable housing applications. Let's move to the next slide, statutory provisions. This is an important definition of what is affordable housing. Essentially, to satisfy the law, the housing has to be some form of deed restricted to the affordable criteria. And its affordability criteria has two dimensions. One is income, the other is price. And we deal with this quite a bit. And there's a resale of an affordable unit. Staff has to make a determination whether the prospective buyer meets both criteria. Now, nobody likes that, especially the seller, because there's lots of instances where that affordable unit is next to a not affordable unit. And with the housing market the way it is, values have gone way up, but your affordable unit, you're limited to the affordable criteria. This is the definition. The development that is assisted housing in which not less than 20 or within 25% of the dwelling units will be conveyed to deeds having these covenants whose income is less than 80% of the area median income, or 80% of the state median income, whichever is less, for at least 30 years after the initial occupation of the proposed development. That's what 8-30G is all about. The area median income, it's not hard to find. You go on the HUD website, they'll tell you what the area median income is. It's a lot higher than people think it is, and 80% is a lot higher than people think it is. So the so-called affordable units, the income, especially in this part of Hartford County, the income limit's pretty high.
Bob,
So-
I was just gonna say, I think I read the recent, it could be hearsay, but article in the paper, you know, something about a 60 or something unit housing project that had 5 affordable units and called it affordable. Now, but that doesn't make sense if it's at 25%. So then would that still be?
How many have to be affordable, Shannon? to
So
qualify?
60 units, that would be 15. Yes.
So it's, yeah, I'd have to go back through and take a look. I've got to read it each time. So there is
Yeah.
a percentage. I think too, the new housing bill's changing some of the percent. I was actually just gonna ask Garrett, because I know this says 30 years. It's a 30-year deed restriction. I think the new housing bill is pushing it to 40 for some of them, so.
Yeah, HB
8,002.
8002, which we have a brief summary of here, changed quite a few of the rules,
Okay.
all towards the end of broadening the scope of affordable housing.
Garrett's raising his hand. Let's see what Mr. Deagle has to say. Go ahead, Garrett.
I believe it's 30% of the units need to be affordable at the minimum. So it could have been that it was a inclusionary zoning project where the town required 5 units be affordable.
Yeah, that makes, a lot of towns are stepping up and saying, we don't like 8-30G. We're gonna make our own regulation that's better than 8-30G. Try to induce developers to use the local regulation rather than 8-30G. The big complaint about 8-30G is you can land anywhere. And all the rules, virtually all the rules get thrown out the window in the name of providing more affordable housing. It's not housing that's affordable. It's affordable housing as defined in the statute.
Well, the one thing that caught my eye it says right there, equal to 80% of the area medium or 80% of the state medium, whichever is less. So, I mean, if you're going by state medium, I think it's going to be a little less than Farmington medium.
Yeah, but Farmington median income is part of the
Hartford County.
SMSA, Hartford County, SMA, Standard Metropolitan Statistical Area. That includes a lot of your neighbors that don't have the town median income. I don't know what it is, but Hartford area median income is on the lower side.
Yeah, I want to say it's in the 120s right now. So the updates provided roughly each April 1st, somewhere between generally sometime in the month of April. And then we've got to redo all of our numbers.
But when
based on that.
when an application comes in, the applicant has to present an affordability plan where they have to recite all of these rules to town staff. Town staff makes a determination whether or not their affordability plan is consistent with the statute. And since it changes quite a bit these days, it's a tall task. This new bill has a lot to it. So next slide. I think we've covered this. Statutory provisions, any person who's
So that's the assisted housing statutory. So the definition of assisted housing and versus the definition of affordable. And that's where the 30% or less of annual income.
one of the issues is when people qualify in year one, over time, inevitably their income increases and they're no longer at that 30%. It's a difficult program to administer. And then they want to sell, they want to take advantage of all the equity their neighbor got on the resale. And towns are in an unenviable position of saying, we can't permit that transaction. A lot of times it's difficult to tell people that they can't do that, but we have no authority to deviate from these rules.
Is there?
No, we've had some interesting conversations. They're trying to shift closing costs. They're trying to shift realtor costs. And these are attorneys on the other side.
They're selling the
So we're having-
contents of the house at a premium.
Correct.
Oh, yeah.
Yeah.
There's all sorts of things they try to throw into it. And we've had to get Bob involved a number of times on these sales.
Yeah.
And it doesn't matter, again, there's been legal teams on the other side that know it's an affordable housing unit. And it took no issue with trying to complicate payment requirements.
All kinds of tricks.
Who's responsible for? Yeah, like I guess like it, like I guess who would come on the other side of that transaction and say the sale shouldn't have gone through? Like who's would?
So the sale for all the affordable housing units that are for sale. So it's Snowberry Cobble, Cornerstone, like Heritage. So the town set, Garrett and I we go through in the deed, it discusses in the declaration how to set the price, the sale price. So there's a maximum sale price.
Mhm.
And then there's a definition of qualified purchaser. And there's documents we have to receive, so tax returns and W-2 forms to try to validate the qualified purchasers. And generally there's a cutoff date. Recently, Garrett at one point was doing these. I think we had for one townhouse, anywhere from 40 to 60 applicants. He was having to do them in batches and just issue them on a Friday.
It's a lot of work. It really is.
And then too, so there are differing incomes that can be considered. So we've had to get Bob's assistance on these. And then we've had to ask for the contract, because the contract, they start playing games with the numbers in the contract. So we've had to ask for the contract, and then we've had to ask for the closing sales sheet. Because it just keeps, they're like, okay, well, the contract says this, but then there's some separate addendum.
We gotta get the HUD one on the closing proposed anyway, to
So-
see where the money's actually going. Because again, they could sell the junky old car for $20,000 to take the money out of the house and put it into the personal property,
Right.
just so they meet that cutoff.
Yeah,
It's a lot of work.
Not relevant to us, but you think, well, you're certain.
well, exactly.
Yeah.
Well, right, yeah, so every time.
No, is it coming out? Like what?
Town
So
budget.
so every time we have to go to Bob, it comes from our town budget.
Yeah.
It doesn't regardless of the question.
But usually Garrett and Shannon bring me the analysis and say, do you agree? Rather than go out and do the analysis. It's a lot cheaper that way.
But yeah, I mean, for any one sale, for some of these, Garrett's put in 40 hours just analyzing the data, right? So for everyone, you've got multiple, for one person, we have to have 2 or 3 years of tax returns and a couple of, right? Because there's all sorts of different definitions for family, right? And so we see all of that. And so you're trying to figure out,
And then it
It's
gets
spread,
crazy because
so
you've got one
some of them are
person-
very
one
straightforward.
person on the deed, they file a joint return. You gotta look at all of it. Unmarried couples that living together as a single family unit. You count both incomes. So they say, no, we have to make a determination of whether or not we have to.
So are you making a different determination who gets the
No,
place,
so
or-
we simply determine whether or not it's a qualified purchaser based on income level.
Yeah,
So
that we-
they can't exceed an income threshold. So we issue a letter saying that, yes, you are a qualified purchaser, you met these requirements, the letter goes out. Or we issue an email saying, and we're sorry for these reasons, you are not a qualified purchaser.
So then
Some
that's-
understand, some do not. But then ultimately, then the home buyer is able to select whomever, or the seller is able to select whichever qualified purchaser they wish to proceed with.
We obviously stay out of that. We're just saying yes or no.
Yeah,
Are towns allowed to charge any sort of fee in this process? Not saying
part
you
of it,
should
sorry.
necessarily,
It's
but just asking.
it's No, right, it's just part of what, so with every so now with the rental properties, so the properties that are affordable but rental, then the owner is obligated to submit, I think they submit to Nancy Parent and they submit to the state of Connecticut. So we're out of it. It's just the ones that are
Right, for sale.
ownership, yeah, the ones that are for sale. So it ebbs and flows.
Right. So Shannon, I know we've talked about this in the past and I don't remember where we stood. Like, and I know there's loopholes and you do a really good job of protecting them, but do we have any legal stance? And I guess this is going to Bob too. I'll give you an example. You know, somebody buys the house, they qualify for it, and then the next year they get a huge pay bump because they changed
I don't have any,
profession.
I don't think we've got any control.
We don't have any control, right? So they kind of like beating the system. You know, I'll give you an example, like, you know,
Well,
the RA goes and buys a house and then all of a sudden becomes a doctor the following year.
Yeah, we get that all the time.
I know.
We get medical residents all the time that come
Right.
in and that's,
I think it might be different for rental properties with short-term leases. They have to constantly prove they're eligible for the lease renewal. But on the single-family homes or the condos or whatever, it's just,
sales, no.
there's just no
Yeah, we
effective
think so.
way
I
to.
remember us talking about it.
No,
It's good.
because they purchased it, right? You can't then,
Once you're in, you're in.
You're
you
right.
can't throw somebody out of their own home that they've purchased.
Is there reimbursement for services through the state, or is that's just
No. Cost of doing business.
gotcha? And in regards to, like, since this gets thrown our way and there's no avoiding it, is there a world in which the town can incentivize these affordable housing projects to go somewhere like a brownfield site to be cleaned up through whatever means, and say, hey, we'll clean this up if you put this here. That way we're not impeding upon the rest of the town or X, Y, or Z. Is there,
I think the new housing bill takes that on a bit.
Yeah.
There's always, and a lot of towns are doing this, they're becoming more proactive in trying to incentivize certain locations.
Yeah.
Because most towns, their stated policy is we support affordable housing.
Right.
Just want to have it located in areas where it makes the most sense.
right? Because you talk about vacant areas, like we've got, I don't know if it is considered vacant, but the old ball bearing and felt factory in Unionville, brownfield site, but cleaned up could potentially be something worth using, you know?
Yeah, absolutely. And that does go on.
Typically, an affordable housing project can't float the cleanup
Right.
and the affordability.
And not to get into the weeds of this, but the cleanup is to the DEP residential
Act.
standard,
Gotcha.
which is a very
It's the
different.
highest criteria.
Highest criteria. And you've got to certify the entire site to the residential standard.
Gotcha.
You know, I've dealt over the years with a lot of Pratt and Whitney property in East Hartford. And
Mm.
been involved with that years and years ago.
Mhm.
But getting that land to the residential standard is a near impossibility without spending so much on it that you could go to lots of other sites. That's why these brownfield sites usually end up in warehouses or some other commercial use.
Gotcha.
So. Next slide. This is the standard, and in this, remember we talked about the burden and the standard appeal, it shifts. You probably know the burden shifts to the town to prove that the denial was necessary to protect substantial public interest in health, safety, or other matters which the agency may legally consider. And those interests clearly outweigh the need for affordable housing. Something like 75% of affordable housing appeals get sustained by the court. In other words, the town turned down the appeal, turned down the application. It was appealed to the court. 75% of the time, court ruled in favor of the applicant because this standard is extremely hard to meet. I defended a denial of a 8-30G application in another town where the sewer allocation for the site was woefully insufficient. 4-acre site, they wanted to put 16 units on 4 acres on traditional zoning, it was zoned for 4 units. So the allocation was for 4 residential units. There was testimony by experts, by WPCA. This greatly exceeds the capacity. The court said, doesn't matter what capacity you assign to that site. What matters is the capacity in the plan. So it said, the court said, you didn't prove that, and this was not provable, that the plant, which was running at 70% of capacity, could not handle an increase in 12 units on that one particular site. Appeal sustained. That's the level of detail we get into. Agency must identify those specific public interests that it seeks to protect by denial. Typically, you see denials because of increased traffic. Road needs to be widened, no sidewalks, things like that. Not going to work. It's got to be something so compelling that the interest in public safety clearly outweighs the interest in affordable.
Can you use school capacity?
No.
So you can't say, they're gonna put in this 5-story building while our fire trucks only reach 2.
Yeah, I mean, that's
Because potentially you could buy them if they could.
I could get another fire truck.
get another fire truck,
Get
call another town.
Your
School capacity is an interesting one because I think you'd have to show that you couldn't redistrict your schools to support the development. It's that level of detail that you get into here, because the applicant can say, what do you mean school capacity? That's, school's been at 92% capacity for years, going down, and these 20 additional kids are not going to bring it to 110%. Like I said, 75 out of 100. That flips on the standard appeal. It's usually 90% favor of the town, 10% the applicant.
Does sorry to cut you off there, but does conservation and inland wetlands have a say at all in these kind of things? Because I remember like Nod Road out in Avon was
Yep.
floodplain, and
Yep.
that was what got it stopped ultimately.
Yeah, they do have to comply with inland wetlands.
Okay.
And-
So it's not just hey, we're doing this, you got to sign off.
No, there's usually more to work with there. in
Gotcha.
terms of public health and safety.
Yep.
But again, it's imperfect. There's not, I mean, it's the policy of the state. It's the
Right.
law of the state. So here again, the agency must, not the applicant, must support its decision. That's why we're so insistent on this record that we all create. Court's task in the appeal is to, based on the evidence, the public interest that the commission sought to protect clearly outweighed. This is an important, such public interest cannot be protected by reasonable changes to the housing, affordable housing development. That gets into the wetlands thing. If you can move it 5 feet to the left of the wetlands protected area, reasonable change, then you got to approve it. Got to give them the opportunity to show that.
So first, I keep doing the what ifs. You don't have the water capacity for major.
Water capacity is a different issue.
Okay.
You can't support the development because there's no available public water supply.
Okay.
Or if bringing the water supply costs, multi-million dollars or something like that.
Okay.
That's the level that it takes to show that the public health and safety issue outweighs the affordable housing issue. Now, on affordable housing, the court, you have to articulate the reasons. The court doesn't have the obligation to search the record. So the reasons for the denial have to be articulated by the commission and supported by the evidence of the record. In a traditional appeal, just the opposite. Court searches the record for the reason. Here, it's the agency's, commission's obligation to articulate the reasons. Next slide. We don't have to spend too much time on the
So these are case law
cases.
items. Yeah.
Christian Activities Council is one of the first First affordable housing appeals, the town prevailed. Glastonbury prevailed here because of traffic hazard, preservation of open space, endangerment of public water supply. This particular site was very rocky. But this is an old case. I'm not sure it'd be decided this way now. So the standards have changed. Next slide. Next slide.
Yeah, keep going.
Yeah, I don't wanna go through.
Yeah, keep going.
Wait, let's stop there for a minute.
Absolutely.
Yeah, I don't think, if this case is decided today, I don't think this public benefit in open space in the MDC land would outweigh the public interest in affordable housing. The cases have shifted in the opposite direction. Next slide. Next slide. Next slide. A lot of time, Chris.
There was a few. Yeah, that's okay.
That
And then that's,
must be
then we're
very
dealing with,
familiar.
we can go right to dealing
Let's
with the.
go with dealing with the press. The reason I'm skipping over that case is I think if we were to defend a denial of affordable housing application now, we wouldn't spend a lot of time citing to Christian Activities Council. It's a good case because it sort of was the first to establish how the courts look at affordable housing appeals. But since then, there've been dozens of cases that are more restrictive than the court was back then. Now, dealing with the press, a lot of this is self-explanatory. If you get a call, nowadays, nobody answers the phone unless they recognize the number. But if you do it by mistake and, hi, I'm so-and-so from Valley Press or whatever, I got a question for you about what I heard last night at the public hearing. It's our advice to politely say, well, thank you so much for the call. Give Shannon a call, and Shannon will call me. Do not engage in discussions with the press. Nothing good ever comes of that. On any pending or potential application, or an application you've decided on that's within the appeal period, because something you say after you vote on it could result.
Quite honestly, I won't make really any comments to the, I will direct them to the information. I will answer questions that are related to public information, but you will probably not see me quoted in the press unless it's quoted from here in our recording during a meeting. Yeah, they call. So here's the information's online. I'll direct them to where everything is online.
When they call me, I say the same thing. I've not been authorized to discuss the application.
Yeah. That's whatever's been put out in the public is what they get.
Yeah, because if you do end up talking to them and you do make a statement, that statement's going to end up in front of the court.
Yes.
Okay, moratorium. This was an issue a few years back, not so much now, but it's basically the authority of the zoning commission to adopt a temporary zoning regulation that prohibits a particular use to give the town time to study and evaluate the need for a revised regulation. What was the one we did a few years ago?
Multifamily housing.
Multifamily housing. It has to be limited in area, limited in duration. You can't say we're going to have a 20-year moratorium. You can say we're going to have a 9-month moratorium. You can't say it's going to be town-wide. You can say in these 5 zones. But it's a temporary zoning regulation, it's actually.
Could we have something like that for the new 8002, HB 8002?
Well, 8002 has so many different aspects to it, some of which turns up into the need to revise zoning regulations. It's possible, I think. Say, you know, it uniquely impacts us, and for those reasons, we need a little bit more time to implement. Maybe.
I think everyone's still trying to figure out exactly what implementation looks like. And some of it's planning studies as opposed to regulation. So, but yes,
This is the OLR bill analysis. They're usually about 2 pages long. 75 pages of OLR summarizing what's in the bill.
Summarizing.
yeah,
Yeah.
I've gotten about halfway through it.
Wow.
So I had sent it to all of you in December. I think I sent it in December along with the full public act, which I think is maybe 2 pages. So I'm not sure.
Yeah, they only shaved 18 pages off the.
Yeah.
actual-
So it's a lot to try to synthesize, and some
Yeah.
of it's. So Garrett and I have sat in one webinar already, and then I can't remember. It's this Thursday or next Thursday. We've got an on-site meeting down in Cromwell to get more of a drill down. And there's a few pieces that have to take place at the state level before everything gets implemented.
The
So
good news
this
is
will
every
be-
town and city is in the same boat.
Yeah.
Well, can you just clarify? So like, I understood it was like effective January 1st, but
So,
is there like some
it's-
delay before?
so give us 2 more slides.
Okay.
Yeah, it worked. It's coming.
Got it.
Coming.
It's coming. 2 slides.
Yep.
1 slide, actually.
It's exciting.
You're right.
I understand.
Next slide.
Yeah, I don't think we've got anything else on moratoriums.
All right,
Here we
here
are.
we go. Connecticut's new affordable housing law. Section by section breakdown.
Yeah, now it went really small.
Yeah.
I just,
Declaration of policy formally states that Connecticut faces a housing shortage and affordability crisis, justifying the need for accelerated legal action. Section 2, 17-member statewide council to guide long-term strategy. The law is explicit as to who is on this council. Recommend zoning reforms, track municipal compliance, and advise on state funding priorities. Section 3, municipal planning requirements. This is where Shannon and Garrett have a lot of work to do.
thanks.
Replaces the current law's requirements on municipal affordable housing plans. And with a new framework, the municipalities could opt into a regional COG, in this case CROG, made plan or develop their own. I don't have any sense of whether being part of CROG's plan or Farmington only plan would make sense or not.
Right, so this is a June 2028 is when this updated plan is required. And prior to then, there is going to be, so from section 2, from that governing body, that's going to be creation of the Housing Council on Housing Development, is going to set an affordable housing number for, I'm going to say, I believe it's an affordable housing number for each region. And then from there, CROG is setting an affordable housing number for each municipality, I think is how this is going. And then based on that, we can either, once we have that number, we have 30 days to make a decision as to whether or not we are going to be part of the CROG plan or we are going to go on our own plan. And I think that number has to be provided to us. I think it's next January. And I'm going from memory. I've got things highlighted and tabbed. I've started. So, and that's, I want to go through it and then I've got to start, and then I've got to come back through and start to break this out with some action items with dates. I haven't finished that yet, but this is going to be an ongoing conversation. But with respect to this element of it, we've got a little bit of time. What it does mean is our affordable housing plan that was originally due up this summer, because it was a 5-year plan that we'd approved July 2021. We don't have to touch that because this repealed, it replaces the current 8-30J, which is the affordable housing plan, and replaces it with the housing growth plan.
So could,
So that's kind of as far as I've gotten. And then there's all sorts of points that go if you have a TOD or transit oriented development and you do this and you do these other, which for Farmington, unless we did a TOD over by Yukon, I'm not really sure where else we would do that. And that's not something we've embarked on previously. Doesn't mean we can't, but unless it's very, in order to get housing points for it, we basically have to say, yes, that can be a TOD. And we have very limited zoning discretion over what it ultimately looks like. It's prescribed very specifically in this as to what we have to allow. And I don't know that the points are worth it. So there is a lot, and that's kind of a little subsection. And then we also have to be working on our POCD, which is on the same time cycle, because our POCD is also due in February of 2028. So there's a lot of work to do in the next 2 years. That's not even application related.
So on that note,
Sorry. So that was section 3.
section 4, this gets back to what we started with, which is clear objective zoning standards, reduce reliance on subjective criteria, e.g. neighborhood character, faster permitting timelines, not sure what that means. Aims to reduce local barriers that historically slowed or stopped affordable housing projects. Very broad statements there. On the objective standards and subjective criteria, the courts have been doing that already. They just will not uphold a special permit criteria that the court considers to be overly subjective, like neighborhood character, because they always ask, whose neighborhood character? Section 5 clarifies and tightens rules around when towns can deny affordable housing proposals. I don't think they needed to do that. Makes it harder for municipalities to reject projects unless they demonstrate substantial public health and safety concerns. We added that word substantial, which I think, again, the courts have already done. This responds to a wave of lawsuits with developers argue towns improperly denied projects. A lot of the developers whose projects get denied hold the opinion that the town is just punting it to the courts, saying, well, let the court decide. The court didn't have to sit through 4 nights of angry public hearings and let the judge tell us we have to do it. That's what this is intended to circumvent. Section 6, incentives for affordable housing production, infrastructure grants, tax incentives, and support for mixed income projects. Priorities projects in high opportunity areas, good school, and transport. A lot of towns, in my experience, are becoming more and more open to the idea of entering into tax incentive agreements with the developer in order to have the developer collaborate on a project rather than just come in and hand in an 8-30G application and say, stamp it here so I can get going. And that, I'm seeing more and more of that. The towns will say, hey, look, we'll go to our economic development people. We support affordable housing. We just want to be part of collaboration, where it goes, what it looks like, how it's structured. Because a lot of towns have been approved projects that they just don't think are good projects. We'll have to see how that plays out. Next. Homelessness prevention and supportive housing, increases funding for shelters, expands supportive housing units, improve coordination between housing and social service agencies. Section 8, accountability and enforcement, requires annual reporting, housing production, zoning changes, affordable unit counts, allows state to intervene if towns fail to comply with planning requirements, This section sort of requires the state to hire enough people to actually do this, which I think they have right now. And then implementation, January 1st, 2006. A lot more to come on this, you know. Everyone's just digesting it now, including CROG and CCM. You know, there will all of these big bills end up with a consensus amongst CCM and CROG and municipalities of how to implement. And I'm certain that there'll be tweaks to this, probably starting in the next session. But this bill, you remember the first version of this bill, the governor vetoed. And then this is the result of the towns and cities getting together with the legislature and the governor's office to come up with what I believe to be a consensus bill approach to this. Not everybody's on board.
That's better than where it
But
was.
this is a major shift. What I said earlier, of local control of rezoning, more to state mandated goals and objectives. And because again, all of this comes from state law. So the state has a lot of leeway in describing what zoning law will be in the state of Connecticut. No such thing as local law of zoning. It's the state of Connecticut through Title VIII, some other titles in the general statutes that tell us how to do these things. Next.
So, real quick question on implementation. So if it's like effective or being implemented now, can we receive an application,
Yes.
you know, under this now, essentially? And I guess specifically some of the things haven't read everything, but some of the things I've seen are like things like the ability to build a residential development in a commercially designated zone, as one example, or there's parking change, you know, requirement changes that like, are those effective essentially now and we can have applicants come immediately?
I would have to look, but I think so.
Yeah, we'd have to look into it, Josh. That's the problem with this was done and jammed in so quickly with such a quick effective date that
Yeah.
everybody's.
Because that's where like you're talking about like 2 years to make these plans, but I'm like, we could get applications now.
Well, right,
What-
but so the plan date for the housing growth plan is a 2028 date, but there's, to your point, there's other things buried in there.
Yeah.
Some may have an opt-out provision, some may not.
Because one question I have, for example, is so on the building residential and commercial zones. So right now our commercial zoning regulations are written for a commercial purpose use,
Yes.
and they're relevant for that and have no restrictions or guidance that's relevant to a residential development. I'm wondering if could we pass zoning regulations that are specific within commercial zones, specific only if a residential project goes in that commercial zone, that would allow us some level of control for those
Right.
projects.
We've got to be careful with that because typically, and Bob, correct me if I'm wrong, but under 8-30G, if your commercial zone does not allow residential by right, either directly or by reference, then it limits an 8-30G application. It can't, and this is under the current regulation, so I'll caveat that there's some wording could have changed. So an assisted development could go in to a commercial zone, but an affordable development could not. So we're back up to the definition when of those slides. Assisted development is like something like the CHFA funded type development. So some of the ones that we've seen recently with Metro at 80 and 90 South Road and at 1600 New Britain Avenue, assisted, there's direct CHFA funding versus Snowberry Cobble, which is an affordable housing development and hits that 30% threshold. So Snowberry was a 30%, Cornerstone was a 30%. So we would not have to accept or approve an application for an affordable in our industrial zone. So we're going to have to start to take a look at cause and effect
Right.
of some of this.
Yeah, the industrial zones under what was current law were exempt from 830G. However, there's an appeal in Glastonbury that the town turned it down based on that. In the court, the applicant was able to prove that even though it was an industrial zone, it allowed commercial uses. There wasn't a single industrial use in that zone, only commercial. Therefore, it was de facto commercial zone. And it's going up to the Supreme Court, I think. But so there's that level of scrutiny on these things. But to your point, if someone comes in tomorrow with an 830G and tells us all about this new law and what it allows and doesn't allow, we're going to have to spend a lot of time sorting through it. So this is, what does the law mean? I think we talked
Yeah.
about all this.
Yeah.
And
I think that's it.
that's it. Questions, any questions?
And anyone online that's called in, if there's anyone else that has a question on that, Ned, I don't know if that's a current hand raised or a former hand raised.
I mean, this was meant to be a broad overview.
Yeah.
Yeah, go ahead.
I have a
Ned.
quick, okay, I have a quick question on a butters notification. So we have a policy based on, and I don't remember what the footage is, but for butters notification. But what if is that state regulation or is that town? Can we make adjustments to that? And I'm for like 99% of cases, I think it's good. But there's sometimes where it's a facility that has heavy use by the town. I'm thinking of like the rails to trails or a golf course or something like that, where it seems like we should put out more notice when there's going to be a project that can affect those. Because, I talked to people about when they were proposing the lower sections of the rails to trails, and nobody knows about it, and it just seems like we should have the ability to, require better notification to townwide in general if it's a facility that is heavily used in the town. Is there a way to address that, you think?
Yeah, there is you would address it through the regulation. What regulations are we talking about here?
So for both wetlands and TBZ, so the TBZ, I forget the general statute that talks about the legal notice requirement, right? And it says you can post a sign, or it requires the sign postage, but it's you can do a butter notifications. There's the wording is permissive.
It's permissive. It's not.
Okay.
It's not required, the statute. And the town of Farmington has taken and placed a 200-foot radius for a butter notifications, which I think, having done this for years prior to being here, 200 is fairly standard for a butter notification for an application. And it's from the property line. And we have implemented that both for our zoning applications and our wetland applications. CBA has the same as well. So it's a 200-foot abutter requirement for those three land use.
Yeah, but that's woefully inadequate for a facility that's going to be affected that's used townwide. That's why I think we need to either make notices on the website or something, and not, something it's on the agenda in our meeting, because, people aren't looking at the meeting agendas.
The agendas posted and the agendas go out via Everbridge. But if you know of other avenues that other communities use,
All right.
that
Okay.
notify, that's
A lot of towns are putting all this on their website.
Yeah.
Social media.
Okay.
To answer your question, you could in the regulations expand the butters area. It's good to be consistent. It's good to be
yeah.
kind
No,
of
I wouldn't,
standard?
I wouldn't do that because I think I think for 99% of the cases, that's good. I think it's when you have a facility that's going to be, significantly affected, that's heavily used in the town, that we should have a higher standard of notification. We could work on that. Thank you.
Bob, to just follow up on Ned's points, can we have differentiated notice requirements based on an objective criteria? So acreage, square footage of a development, dollar value of a project, I don't know, whatever,
Within the regulations, I think you can.
if we wanted to. Okay.
It's in the law that the public notice and the current or whatever, that's jurisdictional. If you don't do that right,
Right, but who reads the newspaper, right? Like, who
And
gets the newspaper?
for the permissive notice, it's not jurisdictional. In other words, if you don't do it right, it's not an automatic loss. If that makes any sense. But within your regulations, as long as you do it on a rational, objective basis, you're free to do that.
Okay, thank you.
Any other questions? You ready for part 2 of the presentation? Just kidding.
Anything else? Anyone?
This has been great. It's, I
It's
feel
a lot.
washed over,
It's a lot.
but yes, thank you.
So the slides will be sent to everyone. So all commission members, for all the land use boards. So the slides will be made available, and sent to everyone. And of course, the recording is available in perpetuity to be reviewed and refreshed as needed. So,
Well, I'll let you get the rest of your agenda. Hope it's not too much.
Thank you, Bob.
no,
Thank you.
no.
Thank you.
Perfect.
Good
Great.
seeing you again.
Thank you, Bob, for coming in. I appreciate it. Good to see you.
Good
Good
night.
night.
Good night.
All right, everybody.
Now comes the fun part.
A little bit of speed dating. So this, I purposely held pretty much all other applications. So your next meeting in January, you've got 4 public hearings coming up.
Woohoo!
you
Yay!
Yes, and then I'm trying to push new business out. So the next the first meeting in February is going to be heavy-ish, and then maybe the second meeting, and it should start to moderate. But yes, you have a bunch of people that are very anxious to see you.
Oh, we're so popular.
So thank you for indulging the reorder of business. So Madam Chair, we are at new business, and if you want, I'm happy to just dive right in to
Proceed.
the first. So the first item of business is 2026 CROG Regional Planning Commission appointments. So there's the letter that was included, and there's a brief summary. CROG is our capital region of government. As a member of community, we're asked to appoint a TPZ member to the Regional Planning Commission for a 2-year term. Reached out to CROG, they were not. So I'm very cognizant that the letter is dated April 22nd. There's a April 2022. There's a February 2024 date. Whatever. The salient points of the letter haven't changed. If you took the opportunity to get on CROG's website, then you poke around and see a few things. The bottom line is there are 2 main responsibilities as a representative for Farmington on the Regional Planning Commission, and it helps keep up to date with the Regional Plan of Conservation and Development, and you also have the ability to comment on and be aware of zoning, text changes, and subdivision plans that statutorily meet the requirement of going to CROG. And those typically are applications that are going to impact a shared boundary, right? We don't have county government, we have our COGs. And so they're overseeing applications that come in that may fall within like right at a town line, typically anything within 500 feet of the town line, subdivision, zone text amendment, or zone change within 500 feet. that the Regional Planning Commission takes a look at. There are 4 meetings during the year. Typically, it's the first Thursday of March, June, September, and November at 7 p.m. and the meeting is via Zoom. So if I can take, if there's somebody that's interested and wants to jump in for this obligation, we're looking for a member and then a backup in case the primary individual is not able to attend. If it's something everyone wants to think about, that's fine as well.
I'm willing to jump in unless anybody else is interested.
Okay,
Don't fight me all at once.
so that's fine. That's great, Josh. Thank you.
I'm happy to be a backup.
But thank you, Dave. Okay. Your contact information will be given to Jacob Knowlton at CROG, and you should hear from him directly when they get closer to meetings. So if there's any questions along the way, feel free to reach out to me. Okay, but I appreciate that. Thank you. Next item of business is a standard. So, Madam Chair.
Okay, so we have an application to accept Big Y Foods Incorporated. So I'm gonna need a motion and a second to accept the application.
I'd like to make a motion that we accept the application made by Big Y Foods Incorporated for special permit and site plan approval for the construction of a grocery store at 500 South Road in a BR zone, and schedule a public hearing for the recommended hearing date of Monday, February 9th, 2026.
And the second,
Second.
okay, all in favor?
Aye.
Aye.
All opposed? And motion carries.
Next we can do
Minutes and Planners.
2 minutes. Yeah, we can do minutes and then I've got planners report. So
Okay,
And vote. If they were. if
oh,
people-
that's right, who can, I can't. So it's gonna be 1, 2, 3 to approve the minutes.
so we can postpone to February.
Okay,
Peter's here. Or January, sorry, the January meeting, Peter.
okay,
Sorry, the next January meeting.
okay, so,
So we'll just roll that.
sounds like a plan.
Technically, if what you're, and we could have asked about, so the, you're certifying by that you've read the minutes and they make sense, but I understand too, if you weren't even part of the commission. So it's one thing to have been absent and a whole other thing to have not been part of the commission, but Peter will be back, so.
Right.
But you're not extra, so even if you weren't at a meeting, but it's something that you've read and you're familiar with, then you can participate in the vote of the minutes. Okay. To 1/20/26, so that's fine, we'll just roll it. Okay, planners report then. I've got a handful of items for you folks. First one up is, and some of these are an FYI. So Winding Trails had a inland wetlands application to our Inland Wetlands Commission, and it was approved at the meeting last week. They are constructing another pavilion on their waterfront to Dunning Lake. So there's currently a pavilion for lifeguards. There's a second pavilion, again, for lifeguards, kind of as a safety location or a first aid, location. And then this is going to be another pavilion that's installed more for their swim lessons during their camp day to provide some respite from the sun because this beach is wide open. The pavilion's going to look like all the other pavilions at Winding Trails. Obviously, because of the proximity to the lake, it required a wetlands permit. really doesn't elevate to the need of a site plan application with TPZ. It's not even as big as a shed, the 200 feet that we have for a shed to require it. So, but did want to make you folks aware in case anyone's in the area and saw the new pavilion going up. It is something we are aware of, and it has been before inland wetlands and received its appropriate permit. Any questions? Okay, it will go to building permit because there's foundations. It's a structure on its public access, so it will go to building. 763 Farmington Avenue, Berkshire Bank. They are being rebranded as Beacon Bank. They're being taken over. So this is a sign package, and this had been uploaded to the website. They got me a corrected sign application, came in Friday while I was out of the office. The only thing that had to be corrected was the size of the directional signs. The original application that you all saw had a 6 square foot directional sign. In our regulations, Article 4, Section 7, the maximum for directional sign is 2 square feet unless there's some unusual circumstance, which clearly there is not at Beacon or aka Berkshire. So you can see up in the upper corner is the original sign on Berkshire Bank, and then this is what it is going to look like now with Beacon Bank. They are within 1.5 square feet of one another. The existing sign is 21.3, the proposed is 22.8. So again, these are a like for like replacement on the 2 building faces. The directional signs are a like for like replacement, and then the ATM signs are a like for like replacement. So unless there's any objection, this was going to go direct to building permit as well. There's nothing new or unique with this request.
I thought it was Key Bank this whole time. I
Well,
forgot
there you
that
go.
they changed it already.
There you go. So, yep, on the curve, on the bend. So, okay.
Okay, great.
So that takes care of that. The next item I sent an email at the end of the day so that you all have these memos. Certainly understand if no one saw them, because again, it was sent at the end of the day. But there is an opportunity. I believe this is through our insurance provider. There's Director of Education and Communications. Oh, no, from the Freedom of Information Commission. So this is a workshop specifically on FOIA. And what I sent to you was the letter from Kathy Blonsky to all of her direct reports, asking us to share this with all of our commissions, which is what we are doing. So this, it's next Thursday at 6 p.m. in the Town Hall Council Chambers. You are welcome to join via Zoom or in person. This is it's an offering. It is not mandatory. So, but you are certainly welcome to participate, again, in person or online, whatever suits your schedule. And it will be here in the council chambers. And this is as much as I know. So we're all going to find out together what this is about. I can check if it will be recorded. I presume it will be, but I don't know that for certain. Okay. Any questions?
What are the refreshments?
Yeah.
Light
Said
refreshments.
light
I don't know.
refreshments,
So I
both
guess
bottles of water.
cookies and water. So,
Okay.
yeah, I wouldn't get too excited. It's not going to be, it's not cocktails.
Eat dinner before you get here.
Maybe I'll just Zoom and have my own.
There you go.
Do it from Iron Horse. Just set up the Zoom. And you'll be
There,
good.
you could. That's another option. And the final thing is I had received a question regarding accessing for those, my new members that need to access our online training. There had been a bit of a hiccup. So Yukon Clear Land Use Academy has And that's all I did. I typed in Yukon Clear Land Use Academy, brings me here. There's upcoming training and there's past training. Under past training has almost anything you could want from a land use standpoint. So there's fundamentals of site plan review. There's more 8-30G information. There's wetland information, basic training for new commissioners. This is a lot of the law, so a lot of this will be repetitive from what you've just heard from Attorney DiCrescenzo. There's map information, and there's slides. And
Shannon,
some of
that's
them-
not the stuff you sent earlier, was it? In
A
the,
lot, it is.
Okay.
So there was just there was some issue with some links for some people. You didn't have any trouble with the
No,
links that I sent,
no,
right?
no.
Yeah. So I don't know if there's a timing. It looks like they may have changed the URL from the time you did it.
Okay.
They like reorganized something in December, which was incredibly convenient. So you didn't have any trouble with links,
No.
but some other individuals are. So that's why I just wanted to run through this. So it is. So I had suggested 2 links. One of them was the map reading, and I think one of them was the affordable housing. Although Bob just did a huge deep dive on affordable housing, and as we just discussed, HB 8002 is going to have even more. So, so this should get you to anything you could ever want to look at. There's advanced training, and the advanced training covers running a meeting and making a decision, bias, predisposition, fair and affordable housing. There's light touch density.
Is there a recording for the map reading? Because when I looked at the slides, it was kind of vague
Okay.
without direct explanation of what each slide was telling you.
I know when I watched it, there was a video.
There was one.
Yeah,
Was
it
it?
lasted probably, it was like an hour and 40 minutes.
Okay.
Something like that.
All right, let me see then if I can, I'll try your link again, Rob, and see if we can get that put together with the map reading.
I remember watching it a couple of years ago.
Yeah, it did.
It was really helpful.
Yeah.
It was
Very
very helpful.
Yeah.
Yeah.
See, I had the flu and I missed out on it.
So let me see what I can come up with. I'll find the map reading one.
Okay.
Map reading.
It's still there.
Okay. And that's all I have for this evening. So unless somebody has a question for me on something, I do not have anything else to share with the commission, other than, like I said, the next few meetings are going to be a little bit of a heavier lift.
I have an address for you.
Yeah. Oh,
S-
Roberts.
Sorry, it got brought and it may already be on your radar.
Okay.
12 Home Circle.
Oh, yeah.
Okay,
No, that's, yeah,
okay.
that, yes.
So it's already being addressed. Okay,
Oh, well,
Because I clicked on it.
well,
we're making multiple attempts.
okay.
Yes. So,
Yeah.
yes, it's gonna be
That's all we
a
need to know.
longish process.
Yeah.
But yes,
Go figure.
Yeah, I drove by today.
understood.
I could understand why they were complaining.
I understood.
Okay,
Yes,
that's it.
okay,
I'm easy today.
Only one.
Only one.
all right. Anything else?
Okay. Any
Thank
questions,
you.
comments? Okay. It's what? We are adjourned.